Good morning. Are you Bernicia Gloston?
Yes, ma'am.
And this is your initial appearance in cause number 25 DCCR 0359. You're charged with burglary of a habitation from February 20th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I'm asked for a court appointment.
Right. So when you're in custody, we automatically give you a court-appointed lawyer. But now that you've made bond, I'm going to expect you to at least try to hire your own lawyer. So I'm going to reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, you're going to get a reset notice today. Bring that to the lawyer and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you talk to, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail for not following that court order. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Ronnie Green. Ronnie Green. This bond will be forfeited for non-appearance and reset at $100,000. Kelly Blanchette or Kelby Blanchette. Good morning. Are you Kelby Blanchette? And Mr. Blanchette, this is your initial appearance in cause number 25 DCCR 0799. You're charged with the 3rd-degree felony offense of obstruction or retaliation from May 21st of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so I'm going to reset your case, give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you talk to so I know you're trying, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Samuel Cadena. Good morning. You're Samuel Cadena. And Mr. Cadena, did you get someone hired?
Not yet, ma'am. I did get a list of lawyers that I talked to.
Who'd you talk to?
I talked to Desmond Parker, Walker Law, Charlie Rojas, Gertz Kelly. They're supposed to call me back, but they didn't.
Okay.
But Thomas and Adam.
All right.
I talked to them.
All right. Who are you gonna be able to hire someone?
I'm thinking about Mr. Parker. I was just need a little bit more time to raise some money. But
Okay.
I think about
Well, thank you for doing what I asked you to. What I'll do is give you about 30 more days to see if you can get him or someone else hired. If it works out, great. Bring that reset notice, like I said before. If for some reason it's not going to work out with any of the ones you've already talked to, talk to a few more. You can tell from talking to them, they all have different payment plans and things like that. Step in front of the clerk. She'll give you a reset notice. Diamond James. Good morning, you're Diamond James. Did you get someone hired? Who'd you talk to?
Yeah, I called a lot of attorneys, but a lot of them don't work with criminal.
Why would you leave? That's the one thing that's important today is
I
to,
forgot it because I had Adrian to work and left work with me.
where are you working?
Brayland Hotel.
Okay,
New house.
okay. So where are you on being able to get someone hired then?
I'm trying to save money so I can go with Mr. Burton. He want 1,500.
Okay. You work full-time at Baymont?
Yes, ma'am.
See. All right, I'm gonna give you one more reset, about 30 days. Try to see if you can get him hired. If not, if you make payments, bring me receipts of those payments. I want to know that you're saving the money and trying to work towards getting him hired, okay?
Yes, ma'am.
Step in front of the clerk, she'll give you the reset notice. Burbank. Okay. Kingston Walker. Good morning. Are you Kingston Walker? And Mr. Walker, this is your initial appearance. In cause number 25, DCCR 0861. You're charged with the third-degree felony offense of tampering or fabricating physical evidence with intent to return or with intent to impair, I'm sorry. And that's for March 27th of 2025. You're also charged in cause number 25, DCCR 0862, with possession of a prohibited weapon. And that's also for March 27th of 2025. And since you've made bond in your cases, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do is reset your case about 30 days to give you some time to try to hire somebody. If you get a lawyer hired before the next court date, just bring the reset notice that you get here today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you your reset notice. Tyron Williams. Good morning, sir. Are you Tyron Williams?
Yes, ma'am.
And Mr. Williams, this is your initial appearance in cause number 24, DCCR 2242. You're charged with a third-degree felony offense of driving while intoxicated, third or more, and that's for March 31st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes.
Did you get someone hired?
I had to pay him his money first.
I'm sorry?
I had to pay him his money,
Who's that?
Benjamin Jeffries.
All right, so what I'll do, Mr. Williams, is reset your case about 30 days to give you some time to get Mr. Jeffries hired. If that works out, just bring the reset notice that you get today to him and he'll tell you what to do. If for some reason it's not going to work out with Mr. Jeffries, then I'm ordering you to visit with at least 3 other lawyers. Bring me back the names of those lawyers when you come back to court so I know you're trying, and we'll discuss what your options are. And do you have, as a condition of your bond, the auto ignition interlock device on your vehicle? All right, make sure you keep that up and don't drive any vehicle that does not have that on it, okay? All right, step in front of the clerk. She'll give you the reset. Diamond Ollie. Good morning, ma'am. You're Diamond Ollie. And Miss Ollie, this is your initial appearance. I feel like you've been here before, right? Or no? I'm sorry? Okay. Give me just a second. It says initial, but I feel like. Did you just bond out? No? So have you already been here and I told you to go hire a lawyer and all that? You haven't done that either. Okay. All right. So I guess this is your initial appearance in cause number 25 DCCR 0532. You're charged with the state jail felony offense of injury to a child, elderly, or disabled individual. And that's from February 1st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Ms. Ollie, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Krishara Bennett. Okay, I knew that sounded familiar. All right, are you Krishara Bennett? And Ms. Bennett, this is your initial appearance in cause number 25 DCCR 0062. You're charged with the 3rd-degree felony offense of credit or debit card abuse, and that's from November 14th of 2024. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Ms. Bennett, is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. I know you've heard this before, but nobody can ever say I didn't tell everybody. Bring me back those names so that I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you a reset notice. Got lots of initials today. Derek Mouton. Good morning, sir. You're Derek Mouton.
Yes, ma'am.
And did you get someone hired, Mr. Mouton? Okay. Did you talk to some lawyers?
Yes, ma'am. I talked to you.
Who'd you talk to?
I talked to Mr. Jones. I talked to Ms. Brittany. I talked to Mr. Kevin Lane, and also I talked to Sean Sanders.
Okay. And so where are you on being able to get someone hired, do you think?
Well, I kind of already know, have an idea who I want to go with. It's just a matter of me just setting up just to get it pick one.
All right. Which one are you thinking?
I'm going to go with Ms. Brittany Holmes.
Okay. All right. Well, thank you for doing what I asked, Mr. Mouton. I'll reset your case about 30 days to give you some more time to try to get Ms. Holmes hired. If you get her hired between now and that next court date, bring that reset notice to her. If for some reason that's not going to work out, talk to some others. You can see that they all have different plans and payments and things like that. All right. Step in front of the clerk. She'll give you a reset notice. Eliza Riley. Good morning. You're Eliza Riley? Elisha? Okay. And Mr. Riley, did you get someone hired? Speak up, please.
I talked to a couple people, but I ain't even invited her.
Who'd you talk to?
Burbank, Macon.
Mr. Riley, if I test you this morning, you can have anything in your system?
No.
Have a seat in the jury box. I'm gonna check your, have you tested first? Oh. Mr. Parker, Timothy Horus, sentencing. Good morning, sir. You're Timothy Horus. And Mr. Horus was previously in court, entered a plea of guilty to obstruction or retaliation. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, Mr. Horus, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement. Find you guilty of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that, place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And if you do all of that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence while you're on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, your probation revoked, and you could be facing that 10-year sentence that you've agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir.
Thank you, Judge.
Do you have anything else?
Nope.
All right.
I'm more nervous than being a judge.
I know. Be careful.
Let us know.
She's on her way right now. Like we're all like, oh. Let's see. Darius Sparks. Good morning, you're Darius Sparks. And Mr. Sparks, this is your initial appearance in cause number 25 DCCR 0754. You're charged with a third-degree felony offense of assault on a family member by impeding breath or circulation, and that's from May 7th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
All right, so what I'm going to do, Mr. Sparks, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand?
Yes.
And also, Mr. Sparks, as a condition of your bond, were you told that you're not to have any contact or communication with Ms. Gage?
Yes,
Right. Why did you pause?
because there's a lot of stuff that transpired. We still start.
No, you're not. Not as of today, or you're going to jail. Do you understand me? It is a condition of your bond that you have absolutely no contact and no communication with her. If I find out that you are still doing that, you will be in jail and your bond bill will be raised so that you don't get out. Do you understand?
Even if she-
I don't care. She can't, you're following my rules now, not hers. Okay? She can't give you permission to break this order. Okay? When your case is all over, or we'll see what happens with your case, maybe that changes in the future. But as of now, because of what you're charged with, she can't say, it's okay, I won't tell anybody. She's still going to be out and you're going to be in jail if you do that. So it's temporary, potentially. You better follow that court order or you will be back in jail. Do you understand? Okay, step in front of the clerk. Mr. Green? Mr. Green, it's important that you're here on time, okay? All right, I'm going to recall that bond forfeiture. You are Ronnie Green, and this is your initial appearance in cause number 25 DCCR 0735. Give me just a second to pull this up. You're charged with the state jail felony offense of money laundering from March 3rd of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am. I actually gave, a lawyer after the payment of
Okay, who's that?
Miss Holmes.
Ms. Brittany Holmes. All right, so what I'll do, Mr. Green, is reset your case about 30 days or so to give you some time to see if you can get her paid off. Bring the reset notice that you get today to her, and then she'll tell you what to do. If you're still making payments, just continue to do that. Bring me a receipt when you come back to show me that you've done that, and then I'll give you a little more time, okay? All right, step in front of the clerk. She'll give you a reset notice. I haven't seen that in a long time. I feel like we had some a long time ago, but it's been a long time. Let's see. Mr. Paget, you have Katherine Castillo,
Yes, Your Honor.
2 cases.
Come on, Good morning.
Good morning, how are you?
Good morning, guys.
Mr. Smith's. You're okay. Good morning, you are Katherine Castillo. And Ms. Castillo in 24 DCCR 2457 is charged with assault on a peace officer, and 24 DCCR 2458 with driving while intoxicated.
This courtroom before. So I know at one point during pretrial discussions, the court had asked very pointedly, and I asked Ms. Beal this question very pointedly, do you care about your phone, your freedom, or your dog? And as I mentioned to the court, I think they're kind of intertwined. Her dog is she tells me, a legitimate service dog that helps her stay calm and focus and be able to function normally. She tells me that she doesn't have competency issues. She just talks fast. I've represented to the court in chambers previously as well as today. I've had multiple conversations with Ms. Beal. She seems to understand the nature of the proceedings as well as what the court's role and my role and the prosecutor's role is with respect to the case. Back to the very pointed question, she had mentioned that the phone, her ability to have her phone then allow her to do those other things to sort of break the cycle that she's in now. The state had offered Ms. Beal a misdemeanor offer of theft. Ms. Beal has declined that offer. She's asked me to set this matter for a bench trial to the court. I know Ms. Nicholson, I'm sorry, was it September 18th?
September 19th.
19th, I'm sorry, September 19th was to be trial by date. So
Justin, could you? I can't, my thing's updating. Jury waiver.
I guess in the end, Your Honor, my question to the court or request to the court on behalf of Ms. Beal is to consider some modification to her bond to allow her to be out of custody while the matter is pending before the court for a trial setting. She's currently been incarcerated about 60 days or so. And thank you.
Let's deal with the jury waiver first, and then
Sure.
we'll come back to, my computer's updating up here, so I have no, we can't pull up her case file.
Okay. Can I just have a moment to vote? Thank you.
Mr. Pageant, what is the announcement?
Your Honor, we
All right, Ms. Beal, I've been handed this document that has 2 signatures on it. On the line marked defendant, there is a signature. Did you sign this?
Yes, Your Honor.
Did you have an opportunity to discuss this with your attorney?
Yes, Your Honor.
And you understand that by signing this, and after we go over what we're going to go over here, that you will be waiving your right to a trial by jury.
Yes, Your Honor.
So the right to trial by jury is one that you do have at this time. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of those jurors of your guilt beyond a reasonable doubt, or their verdict is required to be not guilty, and it must be unanimous. Do you understand that?
Yes, Your Honor.
You still would enjoy all the other rights that you have, your right to remain silent, your right of to confront and cross-examine each of the state's witnesses, your right to call witnesses on your behalf and in your defense. That's called the right of compulsory process, which we will subpoena people if you need them to. You have all of those rights that you will still enjoy, but the jury would not decide the facts. It would be the court. It would be me that would decide whether you are guilty or not guilty. But again, the standard of proof is still beyond a reasonable doubt. Do you understand all that?
Yes, Your Honor.
And this is how you wish to proceed in this case.
Yes, sir.
All right, court's going to make the finding then that you've made a knowing, intelligent, and voluntary waiver of your right to trial by jury, and I will accept that, and we will set this for a bench trial then, according to Mr. Ocello's schedule. Now, with the issue of bond, I know that where are you living?
Before I was incarcerated, I was living at the Hawthorne Inn Suites on Waterstone Boulevard in Mason. It's behind Costco. I've been staying there for the last 3 months, and to leave here, it wouldn't be an issue for me to remain staying there. It's a month by month type of hotel stay. It's not a night by night stay. I've been staying there with no issues. I don't think it'd be a problem for me to continue staying there.
But what was there was obviously an issue with regard to you being released to that place on a monitor. Why?
I was unable to afford the monitor, and pretrial would not allow me to go there without the monitor. And I asked if I could pay for it in a few weeks' time, and they declined that, because I would have to have it before I left the jail.
Dora, what's the situation with the monitor on pretrial?
I am not sure about the payment before release from jail. I could call back to community corrections and ask them.
Cost small.
He suggested that I go to,
Hope House.
yes, sir, and I declined based on the reputation of it being a drug house and it being in the ghetto, and it's not a good place for anybody to do that together, from what I understand.
Well, you know, the problem is you're listening to the idiots over at the jail, and they I don't know why anybody listens to people that are in jail. It doesn't make any sense.
See, I'm not
Those
familiar
people
with
don't have the best information, but it happens all the time.
Did she come from a lower court bind over?
Yes.
He said normally it's like a CPC, they waive it to work with them, but it comes from a bind over from the lower court. I'm gonna put you on speakerphone real quick.
Hey, Ron. My computer here has been updating for the last few minutes. I don't.
I'm looking up this bill right now here. But typically, Your Honor, if it's strictly like a CPC case, we do not hold them up because of the initial payment for the monitor. If somebody's coming from the lower court and it's a bind over, we initially ask for it because they're coming from the lower court. But if they can't, and then they ultimately slide into the bind over with us, and now they're strictly with CPC, we would not hold them up because of money.
Okay. Because right now, again, I'm still trying to pull this up. I love updates and then nothing works.
Your Honor, I printed off the clerk website sheet, like the information. I don't know if that doesn't really provide the detail that you may be looking for though.
It's my recollection from when we spoke in chambers last pretrial that Ms. Beal had been very vague on the details regarding her stay at the Hawthorne Suites, and was not, I mean, because community corrections releases people to hotels all the time, but I'm not sure they felt confident in her either ability to continue to afford it or confirm that she had been there and how long she'd been there. I think there were some issues on that end.
Officer Small, can you have any input into that?
Your Honor, I'm having a hard time hearing that. I'll just come down to your courtroom, okay?
Okay. Thank you.
I've been staying there since the end of May, consistently. I've been in jail for 60 days, so I don't have any money today to pay for the hotel stay immediately. But access to my phone, working with a main contractor, the subcontractor won't be an issue to secure housing again immediately. Money was never the issue, it was life circumstances.
Who do you work for?
Myself, I've worked for Advanced Acoustics for Cincinnati Interiors as a main contractor or subcontractors. And installing things like these in commercial buildings at the courthouse over in Hamilton County, colleges, things of that nature. We had a falling out, so not the main contractor, my business partner and I, so we parted ways. And I'm on my own.
I mean, I'm looking at the previous emails from community corrections and just the information I mean, everything just is kind of vague. There's just not really any definite. You're giving very vague answers that they really can't confirm or deny. Like, for example, you're staying at Hawthorne. What room are you staying in? You didn't even know.
Yeah, I was staying in multiple rooms. I was staying at 203 and I moved over
So
to
there's no stability. That's what we're looking for, some stability to put you out into the community. I don't want you to go out in the streets.
I understand that.
That's the problem right now that I'm having.
And then if I was to be released, I'd be able to gain my own documents for my defense and to show that, hey, this is my phone, this is what happened, this is, just to kind of prove my innocence instead of the information everybody has now, like you say, is vague. And it's kind of like, well, we don't know what's going on. If I had access to my own information, I can show exactly what's going on and have my own defense set up. Even if it's just for a furlough, I'll be okay. I understand it's a lot of information I'm giving you, but to give my defense, I would have to be out of jail to make that happen, sir. I don't have friends. I have a dog. So I don't have.
Well, you don't even have that dog right now. My understanding is that dog is at the shelter, correct?
Yes, Your Honor.
It's being put up for adoption.
I would hope not.
So how are you going to get the dog back? You don't have any money. You can't afford to pay the. I'm sorry.
So I'll be able to secure money right away, Your Honor, with contracting work. I don't.
Well, you keep saying that, but you right now you don't have any jobs lined up, right? You think that you're going to magically get this phone and all of a sudden there's going to be cash, but typically the work has to be performed first.
They pay up on the 1st and the 15th, typically money beforehand or during the progress of the work. I'm not the one doing the things. I'm the one overseeing the workers doing.
Would you
things.
call over to jail and see if there's a holder on her? That could be another issue. I'm showing an outstanding warrant out of Clinton County for an OVI.
Yeah, they don't want me. I went there multiple times. They want me for testimony only, not for conviction.
Well, my notes say there's a failure to appear
I
warrant.
see that Clinton County M1 out from March 1st of this year was the failure to appear warrant.
I went there multiple times. It's for testimony, not for.
I saw that she was charged with an OVI, so that.
Oh, that's like my vehicle, not for the OVI.
Probably, yeah, but yes, I don't know if it's gonna be a holder.
Where's your phone at, by the way?
It's in property here in the jail.
Okay. Officer Small, I know we talked about Hope House for her. She's listening to the jailbirds over there saying that it's not a good place, that it's blah, blah, blah.
We had approached the Hope House, Your Honor, and they said that because of the service dog.
She doesn't have the service dog right now. The service dog is at the pound.
Okay. Then that changes the dynamics because there are children there. So
Right. I mean, why don't we get you out of jail, put you over at the Hope House, get you your phone back, and then we can take the next step once you have some money, and then if you're able to get your dog back and make other arrangements other than Hope House, that's fine. But doesn't that make more sense right now that I know exactly where you're going to be, that I'm not just putting you out in the streets in the hopes that you're going to get these magical contract jobs and be able to pay for a month-long hotel? It just doesn't make any sense.
That's right.
Does it make more sense that I'll release you on a monitor? Officer Small will get you over to Hope House. You're not going to get the dog right now because you don't have any money to get the dog. So, and hopefully you can get your dog back. I mean, I would like to see that, but that'll at least buy you some time to get some money, look into getting the dog back. Doesn't that make the most sense?
That's right. I understand you can't just have me out there nowhere.
And I wouldn't want to. I wouldn't.
She does have a warrant out of Clinton County, but it's only picked up in that county.
Okay. All right. Let's release her today. Put her on a monitor and let's get a bed at Hope House.
Okay, Your Honor.
All right. Thank you all.
Thank you, sir.
Thank you, Your Honor.
Thank you, sir. What's on?
Sure.
Joe? Thank you.
That's when we're back on Wednesday.
Ready, Mr. Clerk?
All right, this is case number 25CR42588, the State of Ohio versus Chelsea Sumpter. Ms. Sumpter is before the court with her counsel, Mr. Clark. Ms. Nicholson, on behalf of the State of Ohio, this is a final ILC violation hearing. Mr. Clark, does your client wish to have a hearing?
No, she's going to admit to the violation.
All right, Ms. Sumpter, you understand you are entitled to have a hearing?
Yes, sir.
You wish to waive that hearing and admit to this violation?
Yes, Your Honor.
All right, the court's going to find that you have violated the terms of your ILC. Officer Bretos.
Yes, Your Honor. I did not know that we weren't going to get to be in chambers, so I did not send a follow-up email.
No, that's fine. You're fine.
I did want to let the court know that her results came back confirmed positive for THC only. Ms. Sumpter and I have had 2 different phone calls while she's been incarcerated, as well as a pretty good conversation right after her initial arrest, about the situation with the device and CIP. I think she agrees now it was a huge mistake, and honesty is going to be our best policy moving forward, as it always has been. But ultimately, since Ms. Sumpter has only been on ILC for a short period of time, I would like to see her continued on ILC. And then I've already spoke to Ms. Sumpter about, I plan on increasing her random drug testing here in Warren County. Additionally, I have set up a River Rocks recovery assessment that she is to complete today. So that would be my recommendation. She's currently at Access Counseling. However, I don't believe that they are meeting her needs for the dual diagnosis that she has for substance abuse and mental health. I spoke with the counselor at River Rocks, who I've had success with in the past. We had a good conversation about Ms. Sumpter, and she thinks she would be a great candidate for their outpatient program right now.
And what about monitor?
Honestly, Your Honor, she had been on the monitor in pretrial. She's been on the monitor for about 30 days after being granted ILC. I don't have concerns about Ms. Sumpter not showing up. I'm not requesting one. If the court would like one to kind of see whereabouts, okay, sounds good.
All right, Ms. Sumpter, despite this violation and based upon the recommendation of Officer Vretos, I'm going to continue you on ILC at this time. She'll arrange for a new assessment to see if we can get something better suited for what your particular needs are, and she's going to increase the drug testing. Look, I ordered you not to use marijuana, and I will stand by that, and I will sanction you, but that's certainly not a reason that you would use a device to try to alter that's just you made a small problem 100 times worse.
I know. And it was a huge mistake, and I am very sorry, Your Honor.
Yeah, you need, if you want to help, if you want to change your life, you need to open up, be honest with Officer Vretos, because she's here to help you. That's the goal of this ILC, is to help you.
I know, you're
Okay?
absolutely right.
So when you lie about things, and that doesn't help anybody, especially yourself. Okay.
You're
All
absolutely
right. She'll be released today.
Sounds good. Thanks, Your Honor.
When you release, come over and see Officer Vretos.
Thank you very much.
Thank you, Your Honor.
Chelsea, you'll come meet with me first as soon as you get out, okay? Just come straight back to probation. You're not even
No.
and then I already have this stuff for today. Thank you so much. Yeah.
Sir, how'd the golf outing go?
Well, Justin hit the ball very well.
Someone's leaving pretty quick.
We finished fourth. It's our worst showing since 2017.
Oh, no.
You're getting the trophy back next year.
I played horribly. Justin hit the ball very well.
Did he? He was the only one showed up?
Now my middle my grandsons played well. My middle grandson, he hits the ball a ton. He just needed to straighten it out a little bit.
I see.
We'd have been putting for eagles, but no, I didn't play well.
They said they had their worst game and they still beat everybody. I don't know what that meant.
Your Honor, I was on the B team. The A team won it. 1 second. I had nothing to do with it.
Yeah, we got beat by them and probation, and then some other team I didn't know anybody on. So yeah, we finished pretty poorly this year.
A lot of
I think so. I think it's certainly suspected, but I don't have any hard evidence.
Love to look into it.
I agree. We'll start an investigation.
I need more blue pens. 2 minutes. No. I'm going. Yeah. You ready?
You are. If you want to go ahead.
Kevin Cooper?
I was in the back. He said.
Kevin Cooper. You don't want to change his mind. Hey, do you have any blue pens over there, please? Blue, do you have any blue pens like these? You can give me a few when you get around to it. From the stash.
Scott, and then I'll.
Print the guy. What? The pens? They're being discontinued. They didn't run that by me.
Buy it in bulk.
Yes,
How much?
not.
What is it?
They did not run
Burn
that
your
by
budget
me.
down, it's on hands.
Using
Pick up your.
charcoal
Shouldn't be.
to rough
Like it flat right there. Okay, you get up over top.
charcoal marking.
Okay, in front of guys.
Mr. Cooper, that's you? Yes. Kevin? All right, we call 22-39843, the state of Texas versus Kevin Charles Cooper, present with his attorney, Mr. West, and the state's attorney. Does the defendant, wave hello. We get some prior convictions here, don't we?
Yes, that's right.
So you're charged with the second degree felony of failing to comply with sex offender registration. And then 2016, it looks like you were convicted of that. And then in 2017. And in 2008. Okay.
In 21.
Well, it ends with, I think they just got tired of writing and.
I thought
But-
you correct.
but- I understand that. What you have to be very careful about, of course, is these priors, if they're in sequence, that makes you a habitual felon. They're not reading that way, but he said there's a 21 and it's not in here and it's not an issue today. But if you were convicted in 21 and
It's not for 3 years.
I don't know, but if that was a crime that was committed after any of these were final, and then you, any of these are final, then you commit thereafter an offense, then you're looking at potentially habitual felon, which is where a minimum of 25 is serious.
That's why I was kind of like, well,
I don't know what that is, but it's not relevant today.
Yes.
But it's something to think about, to be careful about.
yes, sir.
Your Honor, we fashion this as a third degree. The primary count is.
Was it attempted or something?
No, sir. The initial offense he has here would be a state jail felony because of his reporting requirements, is a 10-year requirement. The adding one of the other 3 paragraphs will make it a third degree. The caption on the indictment is incorrect.
What should it be?
Should be a third degree. The caption should read third degree. Because
You said something about state jail felony.
yeah, the original paragraph is a state jail felony.
Well, it takes more than just one prior
No, sir.
conviction.
No, sir, not on
Like a state jail plea, right?
Not on the specific enhancement paragraphs of chapter 62. Because if he's got a prior registration offense, it goes to the next highest degree, which is a third.
Okay, everybody agree with that?
Yeah, John, because one of his priors is felon register. So that's why.
But one of those priors has to be used
Yes, sir.
in the plea.
So that's why I need the initial paragraph and one of the other paragraphs.
Which one?
Judge. To me, it makes no difference, whichever one the
All right.
defendant wants to plead
In
to.
paragraph 1, and again, the defendant waives a formal reading of this and we can go inside.
Yes, sir, please.
Paragraph 1 alleges that
bandage.
that you have a reportable adjudication of indecency with a child. You have failed to comply with requirements under chapter 62, the Texas Code of Criminal Procedure. And it's not the penal code, it's the Texas Code of Criminal Procedure. Is that correct?
Yes, Your Honor.
And which requires you to comply with those requirements of reporting to local law enforcement authorities as your primary registration authority by the Texas Department of Public Safety. And you must report in to Beaumont Police Department. You live here, residents here. And this goes on to allege that you failed to report at least once annually, which is what you're required to do during a period within 30 days before and not later than 30 days after the anniversary of your birthday, June 2nd. So you've got that window 1 month before and 1 month after, 2 months surrounding your birthday to report. And namely, during the period from May 3rd, 2020 until July 2nd, 2020, it is alleged here in Jefferson County, Texas, you failed to verify the information on on your sex offender registration form, which is maintained by local law enforcement. And paragraph 2 goes on to allege that you have been convicted of a similar offense on November 28th, 2016, out of the 331st District Court of Travis County, Texas, where you were convicted of the offense of sex offender duty to register. And thus paragraphs 1 and 2 constitute a third-degree felony. Does everybody agree?
Yeah. Yes, Your Honor.
Which means you face a term of not more than 10 years or less than 2 years in prison if convicted, and a fine up to $10,000 can be assessed. Do you understand the punishment range here, sir?
Yes, sir.
An agreement has been fashioned. In your case, you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You'd be placed on regular probation for 10 years, fined $500. There would be terms and conditions of probation. The very foremost is to register.
Don't have to do
Hold on.
that.
He's already beyond his 10 years now.
That's correct.
Oh,
He had a 10-year period. which
okay.
is
It
now
ended
outside
within
of
10
his-
minutes. All right.
Yeah. so-
Well, there will be terms and conditions of probation, which are normal and customary. Make sure you, they will be reviewed with you and the probation officer here. Make sure you follow them. If you fail, your probation can be revoked and you can be sentenced up to 10 years in prison. Do you understand what you're facing here?
Yes, sir.
They passed this.
How do you plead to paragraphs 1 and 2 constituting this a third-degree felony, guilty or not guilty? Are you pleading guilty voluntarily and because these allegations are true as they are alleged in paragraphs 1 and 2? Yes,
Yes,
yes, she's together. And paragraph 2, that prior conviction in 2016 out of Travis County, 331st District Court in Texas, that's true and correct as it is alleged.
Yes, sir.
And you're pleading true and correct to that voluntarily.
Yes, sir.
Oh, I'm going to show you what's marked as States Exhibit 1. Did you sign that document? Did you understand it? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence
No objection.
without objection admitted. Just one second. What I'm going to have to do is change the caption on this to reflect that it's third degree.
Okay.
You got it early on. So we think the name recognition. So why don't you just, at least it's when you get this, discover the end of the case, you're not. Me. No, they're this, but guys. Yes.
What in some of those, well, like I said, like that, and the university, simplifying the functions. It's not increased and there things that we're going to do.
All right, if nothing further to add, I'm going to find you with pleading guilty to paragraph 1, true to paragraph 2, constituting a third degree felony, a failing to comply with sex offender registration requirements. Under the laws of the state of Texas, you were doing that voluntarily, knowingly, intelligently. There's sufficient evidence supporting you guilty from States Exhibit 1 admitted here. That states that you are totally satisfied with the representation by your lawyer. You were mentally competent to enter your guilty plea. You understand and appreciate the consequences of pleading guilty. You're giving up your rights to a jury trial and the rights to experience confrontation, cross-examination of witnesses, and all of this is true, so help you God. Is that so? States Exhibit 1, part of the record for all purposes. I now find the defendant guilty in paragraphs 1 and 2 constituting this third degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional divisions of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement is suspended. You are placed on regular probation for 10 years. There will be a fine in the amount of $500. Other terms and conditions of probation, which are normal and customary for this office, will be reviewed with you and the probation officer here in just a moment. Make sure you follow these. You know what can happen. Up to 10 years in prison is riding on this. You understand what has happened today, sir? Good luck to you. There. With you. Marvin Lewis on Trevante Moten. You ready on this? What are we going to go on? Which case? Just 5 of them.
Judge, actually, we have a plea. Everything worked out.
Everything worked out. Just got to, we need a week, 1 week to, because there's a thing he's got with
Where's
airports.
Trevante Moten?
He should be outside.
I need him. I want him to sign,
Yes, sir.
tell me that's what's going to happen. I don't want to delay. And then, because that's what happens. Going on. Name on the dotted line. If he is here.
Uh-oh.
Sounds like somebody.
Oh.
Okay.
You better go
There's no
find.
response to that name called here in the courtroom. No response to the name here in the hall. Defendant has failed to appear for the trial docket. A warrant is issued for his arrest for failure to appear. What are his bonds in each?
Judge, I've been an error on my program.
Well, there's still the
On the first case, on the deadly conduct, it's $50,000.
Did you say 50?
50.
828-829?
I've always believed this.
828 is $20,000. $829 is $30,000.
We're negotiating on Mr. Scarpetta. Thank you.
0047. $15,000. $0046 is $7,500.
Okay, let's see if we can do the math on this one. Trevante Moten, in these following cost numbers, has failed to appear for the trial docket. His bonds are revoked, warrants are issued for his arrest on each of these cases. In 22-39866, his bond is revoked to $50,000. It is doubled to $100,000. And in 23 CR 828, $20,000 bond is doubled to 40,000 for delivery of controlled substance. In 23 CR 829, $30,000 bond is revoked. It is now $60,000 bond in lieu, and that's a delivery of a controlled substance. In 25 CR 47, $15,000 bond in possession of a prohibited weapon is doubled to $30,000. 25 CR 46, illegal possession of a controlled substance, $7,500 bond doubled to $15,000. So that's $122,500 in total bonds. Warrants are issued for his arrest, and he must have this is the trial docket, so he must have a GPS device as well. And we will deal with all of that when he is back in custody. So here's Mr. Mullins. Gaggle of cases. We're skipping Gregory Scarpetta just because I want Mr. Gertz to be at the very last. What are we gonna do with that?
But I'm up next. But I'm up next.
234314, Mr. Scarpetta.
Yes, working out a deal on that one, see, just one.
We're pretty close, Jim.
Pretty close.
The excitement is building.
I'm telling you, I'm just right on the edge.
And then I'm next.
No.
No, I'm not next.
No. All right. Horatio Trevino, 23410503. Is he here?
He's present.
Trevino. And I guess Mr. Scarpetta, are you here, sir?
He's just right outside.
Heard that one before.
He's always here, Judge.
Yes, on Mr. Trevino.
Judge,
Yeah.
Mr. Boyd and I realized there was a discovery issue last night.
What do you want to do?
Could we have 4 weeks? I think potentially help us resolve this case without a time.
Mr. Trevino, come on up. We're going to reset this 4 weeks at the request of the parties, please. Get a resetting, keep up with your lawyer. Thank you. All right, next is Daremine Wilson. That's, yeah. That's Mr. Megan again. Where's he? Somewhere?
He's in custody, Your Honor.
Okay, and ready?
And this is a motion to withdraw I filed back in June.
Well,
Still
you know,
want to go
I didn't,
forward.
did I know about it? See, what happens is these things fall into the file and
Right after it was filed, Your Honor, I went into the hospital for a week. Yeah, I'm sorry I never got back with you, but he and his father and his mother and his sister have continued to lie to me about numerous things. And it makes representing him difficult.
all right, I need Mr. Wilson, Daremine Wilson, please. Thank you. Wish we could have gotten this earlier, you know, I just.
It's
That's gotta fall on me too, Judge, because just making advise me about all that at the prior trial setting.
And it just slipped through our cracks. That was when I went to attend assistance.
Yeah, yeah. Well, okay, exactly. When it comes out, to put on the record, there's a motion. The motions talks about health. Your health.
Paragraph 3 is no
but-
longer applicable,
Yeah.
except over the
I don't-
weekend.
Yeah, there's nothing really except communication is broken down between counsel and client. Or we misspelled counsel, but that's okay. I'm not gonna count off for that.
And over the weekend, I had a mishap and fell and I'm out of Kogo and I don't think I should try a case.
Come on up, sir. You're there in mind, Jerome Wilson Jr.
Yeah.
And you are here. Mr. Macon is your attorney. He has filed a motion to withdraw as your attorney. Have you heard that about that?
Yeah.
Okay. And there were two different reasons, health reasons, which he's getting better here, but the other reason was communication is broken down between you and him, according to this, and he is unable to represent you. It's cryptic. I don't understand. I don't know what the details are about that. Do you? Do you know what we're talking about?
No, not really.
Okay, I don't really either, but for the record, if you can summarize, Mr. Macon.
My client, his father, his mother, and his sister have all promised to pay, and nothing has been forthcoming.
All right. Are you able to pay the defendant, the defense attorney?
Paid everything up front already.
Well, how much was that,
7,500.
sir?
7,500.
7,500?
Under the contract I had with Mr. Wilson,
I hate him.
clearly states that there's a trial fee, and that has not been forthcoming.
How much does he?
$7,500 more.
Are you able to pay that? No.
No, sir.
What are you asking?
That I withdraw it. I would say appoint me, but I'm not on the appointed list.
No, you're not on the appointment, yes. The next person on the appointment list would be selected. Anything from the state, Dan?
You know, I have no objections, Judge.
All right, a couple of things. I'm going to grant the motion to withdraw. Keep putting this thing off. I'm going to grant the motion to withdraw, and Mr. Macon will be released. You need to fill out an indigent form before you leave the room on finances. And if I declare you indigent, someone will be appointed immediately to represent you, and we'll set this for trial as soon as they can be ready.
All right.
Give it to him, let him fill that out. And we'll place this back on the trial docket. This is what you want, right? Have y'all talked about disposing of the case?
Making it last.
Exhausting? Okay, all right.
It'll have to be a trial.
Okay, all right. Then I'll keep it on the trial docket, and I'm gonna I'll set it for 6 weeks and get somebody today. Thank you. All right, Vicarious Francois. David, is David here?
I have not seen Mr. Joe.
Called in sick.
But we need to make sure.
Mr. Francois, Jacarius Francois, please. No answer is in the courtroom. I'm asking the bailiff to call into the hall for Jacarius Francois.
Oh,
Yes, just over.
did you talk to him?
I did not.
It's raising such a tax.
I'm always ready.
All right.
Are you Jacarius Francois?
Yes, sir.
Okay. Mr. Grove is your attorney. When was the last time you talked with Mr. Grove about this trial?
Thanks, since like last court day.
Which was when? Help me. I don't know.
Eight.
It was about 2 months ago, Judge.
You haven't talked to him at all since then?
No, sir.
Okay. All right. Are you, was he, did you retain him or were you appointed?
He's appointed.
He's appointed. Your financial status, what is it right now? Is the last thing I have here is no income. Are you still no income?
No, sir.
What, how much do you make?
I do have a job, it's part-time, so I haven't been getting as many hours, but probably like 200, something like that, somewhere in that area.
What do you do?
I clean.
I'm gonna need you to update this financial report and someone will be appointed to represent you.
Yes, sir.
So that we can move on with this. When was the last time you talked to Mr. Grove about this case?
Last quarter. I don't remember the exact date.
The last court date states April 17th, is that right?
Yes, sir.
4 months ago?
Then around that time.
Okay. Was like some of the phone going on something. I'm pretty excited about that.
Sorry.
I'm pretty excited about that.
No, I'm telling you. On the.
Lewis Franklin, John?
Your Honor, that's the place where I was gonna go get Mr. Adams was replaced. I know my name's on.
I don't, let's show him Mr. When were you removed? Recently?
Last court date, and it's supposed to be a plea. They've already done the paperwork, so it's gonna be plea. Mr. Adams has worked out a deal on that.
Where is he?
Right there.
Oh, on Lewis Franklin?
Yes, that's a plea. We sent that to you.
Okay, is it ready?
It's ready.
All right, I need Mr. Franklin, please.
He's right there.
He's right where? But that's the playground.
No, he's behind the wall. He'll be doing, but he goes.
Everyone's mixed up around.
That's on.
I didn't get you anything. Oh, just sets of documents. This is great. I could have used a puppy, but that's okay.
Hey, we're getting this done. We're getting it done. I got that one with Mr. Larry.
All right, on Mr. Franklin, is he pleading to both or one and one to be dismissed?
Just the one is gonna be dismissed.
Okay,
Over here, Mr. Franklin.
which one?
No, he did the aggravated robbery, I believe. He did the aggravated robbery and the kidnapping is being dismissed. Yeah.
Okay, sir.
Okay.
Please raise your right hand. You swear or affirm to tell the truth, the truth, and the truth, and nothing but your right hand, please. You're gonna place that flat right there.
I was in a.
Yes, thank you.
Last week.
You look. Get over more.
Another
And then
one.
this right there.
We making it happen.
Does he have my judge?
That's one off.
We call two cases, 23 CR 27 and 23 CR 23. So it not in numerical sequence, but close enough for government. The state of Texas versus Lewis Franklin, is that you, sir?
Yes, sir.
You were present with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment in 23 CR 27, the first degree felony of aggravated robbery? And can we proceed in summary?
Yes, sir.
And I think part of this agreement, he will be pleading in this case, and 23 CR 23, the aggravated kidnapping case will be dismissed as part of this agreement. Correct?
Yes, sir.
That's our plan. In summary, sir, this indictment alleges in 23 CR 27 that on or about February 13th, 2023, in Jefferson County, Texas, you committed the first degree felony of aggravated robbery. Do you understand what you're charged with here?
Absolutely.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you are facing with this charge, sir?
Yes, sir.
An agreement's been reached in your case, you would be pleading guilty. And 8,
Yes, sir.
it's hard to write on these things. I
It's
know.
tough.
Let me help fix this up a little bit. Yeah, it just comes out bad on these pads. I'm gonna rewrite 8 for you because it just doesn't. It looks like it is the 8 in Mayan, the Mayan language.
The Mayan, huh?
Yeah, the Mayan.
Aztecs, which are basically telling you and stuff. So, we appreciate you. Yeah.
When do we get new pads? These things, when you write up, I know, I mean, it's,
October 1st.
okay. Okay, when I write, but see, when I write, it takes about 10 seconds before it shows up on the pad and then you don't see it. You don't see it. So you start, you don't know if you've written on top of it or.
Somebody would like to fund them before October 1st in one of them.
What you need?
Well, who said that? Yes. Jimmy Ham, yes. We have a Jimmy Ham, yes. He's writing the check as we speak.
It won't be any good, but I'll write it down.
Go to jail.
All right, you would be pleading guilty, sir, sentenced to 8 years in prison and given credit for all time served. And the aggravated kidnapping will be dismissed immediately. Is that your understanding?
Yes, sir.
If I follow this, sir, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Correct?
Yes, sir. It is.
Okay, I'm showing you what's marked as State's Exhibit 1. Langston, help me. Thank you. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, and indictment's been right here. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. Correct?
Yes, sir. Correct.
State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report is waived.
Yes.
I will follow this agreement, sir. I'm finding you are indeed pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this first-degree felony aggravated robbery. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. And the judgment shall reflect that a deadly weapon, namely steel-toe boots, were used in the commission of this offense, as the indictment alleges. You used or exhibited a deadly weapon, namely steel-toe boots, in the manner of its use and intended use is capable of causing serious bodily injury or death. All right, you understand what has happened today? Anything else?
No.
Okay. All right, thank you. Good luck to you.
No. All right.
And we've got a dismissal, right?
Yes, sir.
Yeah, give that to me so I can.
I'm about to send it to you guys.
Got John Mr. Problem.
23 CR 23, the state of Texas versus Lewis Franklin, dismissal. In front of the court. It is signed on this day. Francisco Torres, Mr. Torres. Where'd he go?
I believe Mr. Gert's outside signing up. Mr. Scarpetta, I believe.
Have you talked to Mr. Gertz, sir?
I believe he's gonna talk to him, Your Honor, too, and maybe a plea, but he was signing up. So he said
Have you talked to Mr. Gertz lately?
He did one outside.
I know. Have you talked to him about this case lately?
No, sir.
Okay. Yeah. Okay. Stand by. I think you're in line next.
All right.
To talk to him. Joshua Mendez, Mr. Burbank, Tom Burbank.
Sure, John.
And
We're ready on this call.
State's ready. I'll proceed on the indecency with the child, Judge.
okay.
Are we up, Judge?
Yes. Yes, sir. Okay, here, number one, Mendez. Justin Berry. Brian Lane. Brian, where's Mr. Lane?
We called a motion for continuance, saying it had to be in another court this morning, but
Well,
didn't tell them that they didn't have to be here, so at least Mr. Barry should be here.
Justin Berry, there is no answer in the courtroom. I asked the bailiff to call into the hall. This is.
Yeah.
Yeah, probation. You were Justin Keith Berry? Your attorney is not here. This was set for trial today in. Yeah, we're going on 2 years, by the way. Third degree felony of theft and. Two first degree felonies of illegal possession with intent to deliver methamphetamine and cocaine. For 2 of those are first degree felonies. I understand your attorney is in another court for some reason that we just got a few days ago. This motion for continuance. I've never seen it.
Yes, sir.
But what's going to happen is, who's the attorney on this one? Stay. Okay, you look. If we don't try today, it's number one. Yeah, every docket.
Yes, sir.
Until we try this. Those last minute things. Everybody knows when the dockets come up, and getting something Thursday. Yeah, we got it. But, and I wouldn't have seen it.
Just trial and do
No.
it.
I wouldn't have seen that motion for continuance, but there's nothing we can do about it. But I don't, those don't happen at the last minute, especially when there's a special prosecutor. They don't happen at the last minute. And that should have been filed long ago so that we could have made some arrangements, and I could have at least spoken to the judge to find out exactly what the status is, but I never got a chance to. It's a surprise. Anyway, you're going to sit right over there, and till you are released, and go with that man right now. Okay. And this will be set number one, every trial docket. Okay, go ahead. Reset that to the next trial docket on Mr. Berry, please. Thank Daniel. Terrell Thomas, Mr. Wilkerson, Terrell Thomas. Terrell.
Judge, I got a message from drug court and they were notified that Mr. Wilkerson tested positive for COVID. Oh. Yeah, that tested positive.
Terrell Thomas, he's in jail. Terrell? We're not gonna do. Okay, Mr. Wilkerson may be here. We're gonna wait and see. Casey Taylor. What are we doing on this one? Please? What are we doing?
We're asking to one position and use it. We have.
Four weeks good?
Yes, it's good. And we have restitution. We have to use it.
Yes, okay.
The understanding it's gonna be a
Is that-
plea then.
Do you understand? That's what you understand, ma'am? Well, we said 4 weeks at the request of your attorney, okay? And how much is, what are we talking about? And does she know how to pay the restitution properly?
I believe 4,000, I know there are at least $4,000 just for restitution. Yes, Your Honor.
And do you know where to go to take that, ma'am? Okay, you're gonna tell her if these.
And see how much she can come up with too, in between now and again, if she can. I think we're giving her a chance to try and come up with that, and it's gonna be a plea for sure, but just
No,
to
but how
start
to
off.
pay them?
If you could, pay it through Mr. Samuel, he can write a check to our office or however. it is to do with that.
I'm sorry right now, but that's.
But if you can put however much up to, Your Honor, and then just plea at the time to.
And then what's the plea?
It's gonna be a deferred if she doesn't have.
Oh, okay, and then whatever's remaining is gonna be
Yes,
part
Your
of
Honor.
restitution.
Yes,
Okay.
sir.
All right, we're gonna reset this 4 weeks, and it looks like it's gonna be disposed of at that time, ma'am. And you've got restitution to pay back, which is always in, pretty much always in theft cases. But we'll reset it 4 weeks. Just keep in contact with your attorney, okay? Thank you.
Thank you.
Trevante Nichols. Here's Casey Taylor's phone. Trevante Nichols. There's no answer in the courtroom. Trevante Nichols is in jail. Marvin Lewis?
Yeah, that's what I was looking.
Where's Marvin?
I believe he was trying to track down his other client, Your Honor. They were looking.
Troy Howard is Mr. Wilkerson's as well. Troy Howard
Yeah.
is in jail. Kaden Brown.
Favorite plea, Your Honor.
Are you ready?
Yeah.
Come on up.
Just to be clear, but now.
Kaden Brown
He's in jail.
in custody, please.
Yeah.
This one, okay, so I'm just,
Give me Mr. Rand numbers.
Yeah. Cluster cases from the last two.
Those are perfect.
2, 4, 6, that's 10 cases between the last two defendants.
Brown. Right here.
Go in front of there
Over here, please.
first.
Yeah, oh, here. Yeah.
Over there. Yeah, we're.
Right in front of you, please swear order. I apologize for trying right with yourself.
Yes, you scared me.
Think of your right arm, beat him down on it. Place it flat. Think it up one more time. Look, try to do it like.
You know, so that's.
There you go. Okay, in front of Judge.
Yes, I will. Misdemeanors as well.
Yeah.
Problem with you not having contact.
Yeah, no, that was just a friend, and we just so happened to have the last name. Them is all my siblings right there. That's in the courtroom with my mother. I no longer talk to him or anything.
All right, Ms. Wells, I will give you until Monday morning to report. You are to report to the Warren County Jail at 9 a.m.
Okay.
You understand that?
Yes.
If you come and you're impaired and they refuse you to enter the jail, you may be charged with an additional offense. You understand this?
What does that mean?
It means that there additional charges could be filed against you.
Well, he said about going, they will.
If they don't accept you because you're high.
Oh, okay.
So if you go to the funeral, there's no drinking, there's no smoking, there's nothing, no drugs involved with this. Okay, I'll give you till Monday morning. You report by 9 a.m. to the Warren County Jail, which is right across the street there, right next door. You report there at 9 a.m. Monday morning. That's August the 25th.
Okay, I understand. I appreciate it.
Thank you, Your Honor. Thank you, Judge.
Yep, thank you.
You now call 24 CR 692. State of Texas versus Kaden Michael Brown. That's you?
Yes, sir.
All right. Do you understand what you are charged with here, sir?
Yes. So, Peter. Peter, just so rid of them all, I was about. Oh.
Went through a few hands.
Yes, sure.
Nah, that's the stuff.
We've been working on this one for a minute.
Mr. Brown filed his own. Some of his motions. That was kind of getting delayed, wasn't it?
Yes, sir.
And that shouldn't happen. Anyway.
I'm close to 30. I
don't see any lawyers or interest, especially.
You put me on this one.
Yeah, but nobody put it.
Yeah,
They put it in the file.
So. If you can, you don't.
Sure.
I'm looking. Everybody must have told me. Best, he can do.
You're right, just like. Chum Creek. Huh? Yeah, we lost the date on this screen.
Huh?
It's 8/18, isn't it?
It is.
Date on the screen, but it's quit showing all of a sudden. Wow. All right, the cart for the horse. The court calls 24 CR 692, the state of Texas versus Kaden Michael Brown. That's you, sir.
Yes, sir.
Here with your attorney, Ms. Delage, Jennifer Delage, who's a fine lawyer. And you were charged in this indictment with a third-degree felony of injury to another person. And I think that is a third-degree felony, but tell me what the plan is here.
The intention is to go with the lesser included offense of Class A family assault.
Okay.
These two individuals had a dating relationship at the time.
Again, Class A misdemeanor.
Correct, Judge.
Is that your understanding of the agreement?
Yes, sir.
So, intentionally caused bodily injury, a disabled person by choking. So what we're taking is disabled out.
Correct, Judge.
Okay. And so it's a third-degree felony. It's dropped down to the lesser included Class A misdemeanor of assault.
Correct, Judge.
So that means you're facing up to 1 year in the county jail and or a fine up to $4,000.
That's
Do you
correct.
understand?
Yes.
An agreement has been reached here where you would be guilty, sentenced, fine in the county jail for 1 year. Is that it?
Yes, sir.
And given credit for time served, whatever that is, you will be allowed credit for time served. This is going to run concurrently with 2 other cases.
Both misdemeanor cases.
And then is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this lesser included Class A misdemeanor of assault?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Right. What does, let me ask this family part, what does this do in this Class A misdemeanor, or is that extracted?
Assault family, it's a Class A.
I understand, but the judgment is going to have to show family violence.
Yes, sir.
Okay.
That's to ensure that if this ever happens again, that it's treated as a felony.
And again, how do you plead to this Class A misdemeanor of assault? Guilty or not guilty?
Guilty.
You're pleading guilty voluntarily and because you are guilty.
Yes.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with
Yes.
your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. You are mentally competent to enter this guilty plea. You understand and appreciate the consequences of pleading guilty. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report waived.
Yes, Your Honor.
I'm going to find that you are indeed pleading guilty voluntarily, knowingly, intelligently to this lesser included Class A misdemeanor of assault, family violence. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of this Class A family assault misdemeanor. I'm following this agreement. You hereby sentenced to confinement in the county jail for 1 year. And this will run concurrently with other cases. You understand? Good day, sir.
Yes, sir.
Anything else to add on this? Okay, thank you.
Thank you very much.
Yes.
Please note that that's going to be a family, it has to have an affirmative finding on a family violence on the judgment on Mr. Brown's case. And
Yes.
here. Brayland Toiver. Brayland Toiver. Mr. Reynolds. Mr. Reynolds, once, twice, 3 times an attorney.
When we find him, it's a plea, Your Honor.
Ma'am,
It's a plea, whenever we find him.
Deontay Sostan, John West.
Ready, Your Honor.
Trial.
We're still in that way.
And Alan Richardson.
Same thing.
On Troy Howard's case, we're gonna have to reset that one as well, right? Correct?
Correct.
Everybody, for an issue on one of the attorneys. Okay. So I have Scarpetta.
Forgot. Yes, Judge.
What are we doing on that?
Ready, please, Jeff?
Oh, come on in. See, be in the queue for Brayland Toiver as well. Where's that? Scarpetta. Okay, hold on.
It's busy.
Is it?
Gregory Scarpetta, 41314 is called. You were Gregory John Scarpetta.
Yes, sir.
Present with Mr. Gertrude, your attorney, and the state's attorney does. The defendant waive a formal reading of this indictment and the arraignment here. Can we proceed in summary?
He will, Judge, and you can.
In summary, sir, this indictment alleges that on or about March 11th, 2020, in Jefferson County, Texas, you committed the second-degree felony of manslaughter involving a motor vehicle. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached. In your case, you would be pleading guilty based on deferred or unadjudicated probation, which can be up to 10 years in length. Fine $1,000 and there will be other terms and conditions of probation. It looks like your driver's license has been suspended. Was that right?
It would be suspended as part of the agreement.
Yes, sir.
A loss of life in this?
Yes, sir.
Is this there will be other terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, Your Honor.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
Judge, I'd like to interrupt if I could.
Go ahead.
The parties have agreed to the term of probation being 5 years. I know that Your Honor always makes that decision, but I want to announce that that is what the parties intend. I'll tell
it's the judge's call, isn't it?
It is judge, but you can either hear out our argument later, or I can continue to tell you why we.
Go ahead.
Mr. Scarpetta has no criminal history whatsoever. This arises out of a medical condition.
I don't understand.
It was a diabetic related accident that is the result of manslaughter. The manslaughter is because this has happened on more than one occasion, the particular condition. That's what the state intended to improve as to the reckless nature. It's not, he's never caused the death before, but he's had accidents before. There is certainly a loss of life here. So the parties are recognizing that and moving forward in that regard. He has been on some form in terms of conditions of release similar to probation since the original indictment on this matter, which was back in 2020. And that's what we're taking into account in making that suggestion. And it is a joint suggestion to the court. That I fairly state that.
I think that's perfectly accurate.
And you can see some of what I'm talking about in the terms of the indictment, Judge.
What was he using midazolam for?
It's just an anti-anxiety medication that was prescribed, Judge.
It was prescribed, yes, sir. I had it as an antidepressant.
It's benzodiazepine, right?
That's correct.
It's a form of, yes, sir.
It's a slow acting, and the amount was appropriate for the prescription.
It keeps showing that the defendant ignored the alarm beeping on his device and continued to drive his vehicle.
We believe that's the
on two separate occasions.
Yes, sir.
We agree that's the issue.
That is one of the underlying facts about the culpability, is why it rises to recklessness, Judge.
Recklessness, it arises to intentionally and knowingly.
Well,
ignoring the alarm, yes, sir.
Judge, it's being aware of the existence of that circumstance and disregarding it in a way that created a risk for other people is really what
you think it killed somebody.
Yes, sir.
Judge, I'm sorry, I'm not being sarcastic.
Well, no, I'm not being sarcastic.
Sorry, I'm not
All
being
right.
sarcastic.
Well, no, I'm not being sarcastic either. Is why somebody, we have a victim who is deceased. This is the second occasion that he had an issue concerning this matter in another automobile accident.
Yes, sir.
So which was how long before?
A number of months.
Within
A few months.
Yes, sir.
A few months. So he, but he is going to admit to committing the second degree felony of manslaughter.
Yes, sir.
All right. And y'all are asking for a reduction in the probation term.
We're informing the court we've agreed to 5 years.
Okay.
Your Honor, we always know that you get to make that decision.
Okay.
I've given you our reasons.
All right.
We respect whatever you decide, Judge.
Okay. He is still eligible for release in 1/3, is he not?
He is,
Again,
Judge.
that's notwithstanding.
There's no exceptions on
All
that.
right. Because of my strong belief of the sanctity of life, the loss of life has its price. And I hear what y'all are saying, but I intend to follow the agreement, but he's going to be placed on 10 years probation.
Thank you.
And then he will be eligible, doing well, to release on 1/3, which I do all the time, if he does well. I'm concerned about a second event like this happen, and then you working off here on probation and driving another vehicle.
Judge, I will weigh in on that.
Yeah.
And on my research and preparation for the trial, multiple trial settings we've had. I've been pulling medical records, and Mr. Scarpetta had a history of events that arose up until this particular incident. But the good news is that he hasn't had any incidents since. And again, I weighed all that in and making the decision that I did.
And Judge, part of the reason we're agreeing to the suspension of the driver's license is for that reason, but also, Judge, because he has not driven a vehicle since this accident. So he's had a person driving him. He does not drive himself. That will not change as part of this. And we know that would be a term and condition of probation.
What, at the time of this event, was he under any kind of court order?
No, Judge.
No.
Okay.
And he had actually been through a review by the medical board with DPS in relationship to a separate incident, was given back his license, and I took exception to that, which is why I've been pushing the issue about the driver's license.
But it's also the difference between a manslaughter and a homicide.
So again, Judge, I'm just letting you know, we have, Mr. Gertz and I have beat each other up about this incident pretty much for the last 5 years.
So we got time to.
All right, it's time to resolve it.
Yes, Judge, we're.
All right, in 23-41314, your Gregory John Scarpetta, with your attorney and the state's attorney, does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed to summary?
He does. And we can.
In summary, this indictment alleges that on or about March 11th, 2020 in Jefferson County, Texas, you committed the second degree felony of manslaughter. Do you understand what you were charged with?
Yes, sir.
If convicted of this, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached between the parties where you will be placed on deferred or unadjudicated probation, which can be up to 10 years in length. Fined $1,000. The driver's license would be suspended. What's the restitution on this? Is there, there's a loss of life.
There is,
There's
but
gotta be.
I've never been given a figure of restitution, Judge.
And I believe.
Well, it's for the probation to determine because if there's restitution.
That'll give me one more chance to get with the victim's family to ensure that there's not additional restitution, Judge.
It may be insurances, other forms of payment have been made. But the court is, if there is restitution that is owed we're gonna have a hearing on that so the court can resolve it.
Yes, sir.
Unless all the parties agree.
Yes, sir.
And that will be included in this judgment if it is applicable.
We understand.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of this manslaughter? I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
We have no objection.
Without objection admitted. This states you are mentally competent to enter your guilty plea if freely and voluntarily made. You know what you've been charged with in indictment. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the records without objection.
We have no objections, Judge.
I'm going to follow this agreement with nothing further and find you are pleading guilty today to this second-degree felony of manslaughter voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I am going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. If you do well, it can be shortened to 1/3 of that, 3 1/3 years.
Understood.
There will be terms and conditions of probation, which are not only normal and customary, but special for this particular offense circumstance. You will be fined $1,000. Your driver's license will be suspended until otherwise ordered by the court. Restitution. The court finds restitution is an issue in this case, which if restitution is owed, shall be paid. I will have a hearing on that if it's deemed that there needs to be a specific amount. I am going to order restitution if not otherwise reimbursed to the victim in this matter, because, and that's done in every case where there's a loss like this. But I don't think we're ready to determine, but I think all the parties agree if there is, it's normal and customarily part of a probation term. There will be other terms and conditions of probation, which the probation or officer will review with you. Please follow them. If you fail, your probation can be revoked, can be found guilty and sentenced up to 20 years in prison. Do you understand what has happened today, sir?
Yes, sir.
Any questions of me, or do you understand fully? Okay.
Yes.
Tragic event.
Yes, sir.
What have you done to ensure that this won't happen again?
Many things.
Yes, sir.
The most important is carrying a higher blood glucose level.
Yes, sir.
And monitoring and maintaining.
Okay.
I did have a pump malfunction on one individual pump. We since have moved to a different manufacturer, and it's
working better
flawlessly.
Okay.
The last 4.5 years.
Fine. Okay. Please see the probation officer. Thank you. Oh, he needs your print. Real quick. Thank you. I have Brayland Toiver. Is that in this? Yeah, Brayland Toiver.
A little bit darker than that. Now you know.
Insurance. But the 24 CR 1209.
I'll meet Mr. Tolliver's. Well.
You'll see her first.
Yes.
So raise your right hand, please. Swear or affirm. Cover your truth and truth help you God. Keep us your right hand front. Right. Okay, place it flat right there. Okay, ink it up one more time and place it right here. Don't roll it though, okay? Just place it flat. Now, I don't, yeah, let's see, Judge.
24C or 12009 is called Brayland Toiver. That is you.
Yes, sir.
With your attorney, Mr. Reynolds, and the state's attorney, yes, the defendant waive a formal reading of this indictment and arraignment. Can we proceed in summary?
He does, and you may.
In summary, this indictment alleges that on or about May 4th, 2024 in Jefferson County, Texas, you committed the third-degree felony of deadly conduct with charge of a firearm. Do you understand what you were charged with?
Yes, sir.
If convicted of a third-degree felony such as this, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir, I understand.
An agreement's been reached in your case, you would be placed on deferred or unadjudicated probation for up to 10 years and will fine $500. There would be terms and conditions of probation normal and customary for this type of offense. Is that your understanding?
Yes, sir.
Of the plan in this case?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will.
Yes, sir.
Because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney or the content?
Yes, sir. Yes, sir.
State's Exhibit 1 tendered in that.
No objection.
Without objection. Let's admit, among other things, the state you are mentally competent to enter your guilty plea freely and voluntarily made. You know what you've been charged with. That has been read here. You've read it. You are guilty of the crime first and any lesser included offenses. You are given of your rights to and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived here?
So wait.
I am going to follow this agreement. If nothing further, and find you are pleading guilty today voluntarily. You're competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and postpone this so long as you follow these terms and conditions of probation. This will be for 10 years. You do well, it gets shortened to 1/3 of it, 3 1/3 years.
Thank you.
You must pay a fine of $500. There will be other terms and conditions of probation, which are normal and customary. Again, we don't like to talk about failure, but if you do,
No, sir.
your probation could be revoked. You could then be found guilty and sentenced up to 10 years in prison. Okay. Fix this.
Yes,
You
sir.
can fix it.
Yes, sir.
Okay. Good luck. Yes, sir.
Yes.
Thank you, Judge.
Thank you. Both. Yes, sir. Sign off. Here. All right, let's see what we have. Okay.
It's good, we haven't, so we haven't heard of Mr. Bird's off Francisco Torres.
Taurus,
And
where's-
where Mr. Gertz went.
where are you?
Doris is right there.
I see him, but his lawyer, they're the ones who are missing. Ryan Gertz, once, twice, 3 times, an attorney? No. There's another line in that song, but that's
Right. We also have, Devontae Nichols with Mr. Lewis that we, he didn't.
Yeah, I put a line through that on Trevante Nichols, I guess.
Mr. Lewis one.
Yeah, you weren't here, so I passed it. And what are we gonna do on that?
It's a video that we were having some issues with, but we've gotten it resolved. Mr. Boyd is getting everything ready for me. I was gonna ask about 2-3 weeks, and we should have it ready for.
What do you want?
That'd be fine, Your Honor. We weren't able to open it. We were finally able to get the detective up here to get it open. I think it will work it out with the video timeline.
You were doing this on the day of the trial?
We've been talking about it.
Well, no, but there's still, you didn't see something till today. Come on, that's kind of.
Well, it wasn't
late in the game.
We weren't able to get it open until that. We've been trying
545 days?
Opening it with I've been trying to open it with the program and it wasn't opening.
You used the can opener?
We used a different program and we were able to get it open.
How much?
I was saying about 2-3 weeks.
3 is good?
That's good.
Yes, sir. We'll have the timeline.
Okay. Nichols, reset.
Set for trial still or?
Yeah, put on.
You know.
Okay, all right.
And Mr. Moulton, Judge, I do have it.
Here's Trevon. Nichols.
Did Mr. Moulton show up?
Yeah, he's here. He's in
Okay.
3 cases. One.
Okay, Judge Devon forfeiture from this morning is here.
Who?
Mr. Moulton, Judge.
Mr. Moulton? You have $122,500 in bonds. Where are you?
Mr. Moulton.
Come on up. The court will order that you be taken into custody when you don't show up. What happened?
ETA was at 9:10 to the traffic. I'm from Cornelius.
Okay, well, you're the guest of honor. You got to. There were others who didn't show up, but that's what happened when you show up late.
Judge, this one we asked for a week so we're close to working it out. We just need to get the.
We're back to bonds. They're revoked now. Don't be late. Okay, all right. You gonna fix this?
Yes.
Start early. Okay, we're gonna pull all that back. How much time?
The next week, Judge.
1 week?
Yeah, 1 week.
Per week.
All right,
Hopefully.
okay, good. Resetting 1 week set. Be careful on these, I mean, about everybody being here. Do you have his files?
They're right here.
Okay,
I'll email you.
Okay.
all right, so Joshua Mendez is the first one, right? That's in line, everybody follow?
I know Judge Morgan said he could take a case today, but it's gotta be somebody you have.
Right. Joshua Mendez?
He's in custody.
Yeah.
And I think I took those, Judge.
Did you put that?
I
Give me
did
his
here.
file. Okay. Yeah.
Yeah.
2 cases. So there'll be Mr. Ham.
Yeah, Judge, I'm ready. That one would proceed on the indecency. I would also advise the court on Terrell Thomas. We're waiting to hear from Mr. Wilkerson. This case is actually older than what shows because it's been. I'm told he's here. I was told he was in Judge Shelton's court and would be here as soon as he's resolved there, Judge.
Yeah. I'm not sure. Okay.
But I just want
Those aren't
you
the kind of cases that people go to jail in over there. These are the ones that the Constitution's all about.
Yes, sir. I just want the court to be aware that Mr. Thomas is a habitual offender.
Okay. And he's number 2.
I would go on the aggravated.
Okay, he's number 2 is Darrell Thomas.
Judge, Mr. Gertz said he's coming back to announce on Torres.
And then Terrell, okay, then Horus. Are we ready on that one, Mr. Boyd? Horus?
That will still need the entire lab file. We got part of it. We need the entire, the complete lab file. We have part of the lab file, which you do have the.
No, I don't need you right now. We gotta wait for your lawyer. I'm talking to him about something. So we can't try this today?
I'm gonna request the entire file. That way we can have
To win. How long?
Daniel, what are we, it's already 900 days.
2 weeks, Your Honor, I can get it probably within a week.
All right, that's 1,000 days old, man. So, okay. Did I say 2 weeks?
Yes, sir.
So again, we got this and Pharrell Thomas. And then I have Francois has to be reset with a new lawyer. That's not file.
Judge, do you, you want to bring them up? She filled out the indigent affidavit.
Oh, in a minute. Then Troy, Howard. Those are Mr. Wilkerson's. Yeah, but he's in civil court. It's just always. We're gonna try. Interesting. Since you don't go to jail over there. So. And then Sustand. And Richardson. Okay, in those orders. Here. Thanks. Cody Garrett. Yeah, so be that. Give me all you can get.
There's half the stack.
Which one you want to?
Cody Garrett.
Cody Garrett. I have to read this already, please, off that I can tell. Can you say anything with that?
What are we gonna do on him?
We'll just one reset on him, but the other ones.
All right, Cody Garrett. Is it reset?
That's a reset, regular reset.
Where is he? Mr. Garrett? In custody. All right. Cody Garrett, and how long?
4 weeks.
Reset Cody Garrett, 4 weeks. Thank you.
But I got pleas with Parker, Gill, and
Gill. Elijah Gill, please.
That's ready to go. And Smith is also a plea.
Thank you.
That's ready to go.
Jesse Maddox. Did you keep that one? Jesse Maddox. I don't have it. It looks like it was recessed. Okay.
You would roll off. He's not taking his notice. But these other three are sleeping.
Well, okay.
Okay, who's the?
Elijah Gill.
He's ready.
Okay.
He's
Fingerprint.
Go see that lady real quick. She's gonna swear you in. Thank you. Motion to revoke probation.
Right, we don't choose big today. That's a count of 5, I got the 6 something.
Desmond Parker. Where's my hand? Or
He pleading true to the marijuana.
right, thumb. Yeah. Okay, place it flat right there.
You're through.
Place it flat right here. Don't roll it. Okay. There we go. Yeah. Go stand in front of Judge.
I told him.
3CR 377 is called the State of Texas versus Elijah Ray Gill. Is that you? Present with your attorney, Mr. Adams, and the state's attorney is present. There is a motion to revoke unadjudicated probation here in this case, as you have been on probation since December 18th, 2023 in this court. Deferred or unadjudicated probation. You will raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. All right, lower your hand. Thank you. In summary, we can proceed in summary?
Yes, sir.
In summary, this motion to revoke probation, sir, states that on December 18th, 2023, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation for the 3rd degree felony on a public servant. Is that true? Yes, sir. Allegation 2 states you failed to report to the Jefferson County Probation by mailing in report online for the months of January, February, March, April, May, June, July, August, September, October, November, December 2024, and January 2025, as required in the court's directive to you in your probation order. Is that true or untrue?
Untrue, Your Honor.
You did file those reports?
Yes.
Okay, good luck on that one, because we're gonna hear, there's the lady here, and what do you want to say?
True to that, the marijuana officer.
I don't care, but I want why you got to report or else you're not on probation.
Oh, I thought, well, when I was on probation, and I was in at 3300 Old Spanish Trail, I asked my probation officer, Mr. Ryan Wynn, and I told him about the things that Jefferson County wanted me to do. He said that he reports to Jefferson County every 6 months. So,
Yeah, I don't know what that means, but hold on. I'm showing this. Is that your signature? That's your signature, isn't it? Yes? Okay. This is, you signed, and there's my signature right above you. You signed this. This is the probation order that you were placed on December 19th of 2023. And it states, among other things, that you've signed that you must, among other things, report as directed. And what we did for you as a courtesy, because you lived in Harris County, we don't have to do that. Well, I can make you come over here in person, but I don't. That's not really fair, I don't think, unless people just fail to report. But I was accommodating you, but you are under my probation. You're not on somebody else's probation. It's my court order. And it says, you have to report. And we work with you, though, to report by mail, which we haven't. The probation officer is right here behind you. Yes, she would know. And this states you failed to report mailing. Did you mail these in to me? Yes. Okay. All right. This was in violation of condition 4 of a special amendment that was filed on January 31st. Hold on. Well, I don't have a copy of it, do you? From probation?
No, I didn't.
I have an administrative hearing on January 23rd, which went through his violations. It says, there have been multiple attempts to contact him. All have been successful. He does not appear willing to comply with any referrals and has made himself unavailable for this supervision. Were you in supervision in Harris County with a case out of Harris County?
yes.
Okay. All right. Well, what we did was we worked it for you so you didn't have to be in person all the time over here as a courtesy, but you ruined that by not following the rules. It says on January 13th of this year, Harris County closed their interest in this case due to you failing to report to their office as directed for the months of November and December of 2024. On January 8th, a field visit was attempted by the Harris County Probation. No contact was made due to the address that you gave was invalid. The address listed on the closure letter from Harris County is a different address than the one you had originally reported to this office. You've never provided an address change to this office. You have been referred to complete community service hours, but you have not even started performing them, according to this dated January 28th to 25. So that's 8 months ago. You failed to report by mail or online each month. There have been no payments made in this case. You were delinquent $1,000 as of January. You failed to report to the Harris County for your drug screen as directed on October 10th of last year. On October 11th, you tested positive for marijuana. You failed to attend the Harris County Cognitive Program, which helps you make better decisions. Multiple attempts have been made to contact you. All have been unsuccessful. You don't appear to be willing to comply with any referrals and have made yourself unavailable for supervision by this office. And then I saw that and I go, well, that's not good at all. So, all right. Okay. So here we are. We got a motion. That's true. A motion to revoke probation. Okay.
Judge, I showed him the amendment that he signed.
All right.
I found it in the court file.
Number one states you failed to report to the Harris County Probation Office for the months of November and December of 2024 in violation of your probation order. Is that true or untrue?
Yes, sir. That's true. True.
Stand by.
No.
Two, you failed to report to the Jefferson County Probation Office by mail on all those dates. Is that true?
Yes.
That we talked about? And
Number 5, I think.
5 states you failed to abstain from the use of any and all intoxicating substances, including alcohol. You provided a urine sample on October 11th of last year that showed the presence of marijuana in your system in violation of your probation order. Is that true?
Yes.
So are you pleading true to allegations 1, 2, and 5 of this motion to revoke unadjudicated probation filed in this case on February 6th, 2025? Are you pleading true voluntarily, knowingly, intelligently, and because those allegations are true? Yes, sir. That you pleaded true to?
Yes, sir.
Do you understand that a plea is true, voluntarily, knowingly, to one or more violations of probation? That is enough to grant the motion to revoke probation. Your probation can be revoked. You can be found guilty now and sentenced up to the full range of punishment, which is no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. There is an agreement that's been reached. Whatever sentence shall not exceed a cap of 6 years in prison. If I follow this agreement, I intend to do this. Follow this. You have no right of appeal. Do you understand?
Yes.
You sign this document, States Exhibit 1, understand it, discuss it with your attorney, or the contents all true and correct. States Exhibit 1 tendered into evidence without objection admitted. Among other things, this states that you are giving up all rights of appeal if I follow this agreement. I am going to follow this agreement. Now, you have pleaded true to allegations, again, 1, 2, and 5, and of this motion to revoke probation. And I'm going to follow the agreement, but let me hear from the lawyers, beginning with Mr. Adams on behalf of the defense.
All right. Mr. Gill, you accepted responsibility, right? Yes.
And you're swearing all statements you make during this hearing will be the truth, the whole truth, and nothing but the truth. So help you God?
Yes.
Okay, go ahead.
All right. And you understand that the most, according to this plea agreement, the judge can put you in PDCJ for 6 years, right? But at the minimum, the judge can continue you on supervision, right? And you're asking that you be continued on supervision, right? Yes. So what I want you to do in your own words is tell the judges why you want to be continued on supervision and not sent to TDCJ for up to 6 years. Tell them why.
You know, I know I made a mistake, and I'm very aware of it. Which is and if you can find it, if you can find it in your heart to give me a second chance to reinstate it, I'll take advantage of that. Sure.
We gave you a second chance when we put you on probation.
Yes, Your Honor, I understand that.
Hey, what has happened to this evading arrest or detention with the motor vehicle probation out of Harris County? You did?
Yes.
Okay. And then you got this theft, I guess a state jail theft of property in 23. And that was 7 months in the state jail. Okay.
And I think earlier,
thank you.
I think earlier you had testified that while you was on probation on this case, you said that you was on probation in Harris County, right? So basically in Harris County, when you got this situation, you're saying in Harris County, they didn't revoke you? So in Harris County, and they continued you on supervision, right?
I got reinstated on May 12th. I was supposed to report on June 3rd.
So, well, if you're unable to report because you're in custody, that doesn't work against you. You can't metamorphosize yourself and become a spirit and go. And so you will not be punished because you were here.
Yes, sir.
Go ahead.
If I could say something, Your Honor.
Yes, sir.
I am.
How much credit does he have, Thompson? No, I'm sorry. Thank you.
I want you to be aware that I have the support system now and everything for me and be ready. My mom has the support system for where she has 2 other boys and we're right now working, looking into search jobs. And I was supposed to go to school this May 12th still to finish my GED at Houston, Canada.
Yeah, that's important.
Yes, Your Honor. And I was looking forward to going back to school, Your Honor. And I have all the support that I need right now that I've built from them. And I guess all I've been asking is for a second chance, Your Honor.
And the thing with the marijuana, are you agreeing not to use it?
No more. No.
And then it's
promise.
I promise.
And then as far as the other thing with you not reporting, well, obviously you got to report in Harris County, right?
Yeah, but I'm facetious about it because everybody promises, but not everybody follows through with it.
Yes, Your Honor, you have my word.
I know they all have. I have all their word because you sign all these documents. Everybody signs a probation order and swears they're going to follow it. But you'd be surprised how often we're here. Although we have a 92% success rate in this county, which is far better than the national average.
And Your Honor, I have motivation. My granny and my mother have been a motivation since I've been talking to them in custody, and they want to see me do better. And I actually want to be able to, you know what I'm saying, before they pass away or anything.
Yeah,
if they know that their grandson and their son has something.
Yeah. Oh, so have you come to understand now that your life touches other lives other than just you? Yeah, that's the reality of life. Some people never get it.
The unnecessary actions, I wouldn't want to lose the people that I love and care for.
Yeah, no, but here you are. You were on probation. We went through all that formality, and then we're not reporting. We can't find you. We lost you. Using drugs.
Yeah.
Did you tell your family where you're buying your drugs from, or where you're getting your drugs from? Did you tell them? Mm-hmm. There are some things you won't be forthright with your family, are there?
No, Yeah, I learned since being in custody that the first thing was the step of just being able to be the max potential is not to lie to myself.
Mm-hmm.
And that's what I've been trying to do.
Okay.
So the bottom line,
but you did make a promise that you didn't keep here on probation when you swore you would do this. And okay.
So the bottom line is you're given a second shot or a third shot, I should say. You are going to report. You're going to do And I guess because the judge in Houston could have revoked you and sent you to prison, right? So you really asking our judge to help you out as well, right?
If you're just trying to, I'll follow through all the stimulations and everything thoroughly.
And I'm curious, what happened in Houston as to why the judge up there didn't revoke you? What happened?
When I went up there, the lady, the judge, she told me that, you know, you are serious and you had a promise basically, like how you're telling me on. And it was like, but I see a second chance. And
What was, so what did she say? That you're what?
Like basically signing, like the things that she told me, like I should have been aware of, like things like that.
Like for example,
dirty UA.
The first thing on this, the first probation or the first term is don't commit a crime. Using a drug is illegally is a crime.
Yes, she continued by saying that
what are you on probation up there for? What's a crime?
Invading.
Say that again?
Evading and unauthorized.
Evading. Okay. Running from the police. Right? Is that what? Okay. Let me ask probation office. Sound in. Succinctly.
Well, I've tried, I've made many attempts to get in touch with Mr. Gill. I made many attempts to get in touch with his officer as well. I'm assuming the officer changed.
I just talked to him while I was in there. My mother was supposed to, she said she got in touch with you. You said that you didn't even know that I was in custody and that I had already gotten stated by Harris County.
Yeah. I don't know how to supervise him if I can't contact him.
We're free falling when you're not in contact. You're really not on probation.
Looks like you also, they've been trying to get him to do the cognitive program.
Yes.
Thinking for a Change is what it's called, and they couldn't get him. He just wouldn't, he didn't attend.
That's the Zoom.
He's free falling.
Yeah.
What state suggesting?
Judge, can't get a hold of him, can't supervise him. We can't do anything with him. But when he gets in trouble, he comes up here and talks all the right things. But the reason he's in is because he wasn't following rules at the jail and hit a jailer with the phone, beat him with the phone pretty bad. So he's been given every opportunity, and he sounds really good with his voice, but his actions just don't back it up. So I think that's the reason we were asking for pen time on it, because if he's not going to report and give us the correct address and be supervised, and the only place we know where he's at is in jail.
What are you asking? How much?
6 years.
And back here.
Your Honor, when I know you said that I was supposed to mail and everything, but everything since like with the location wise and everything like that, I let my probation officer, Mr. Ryan Wynn, let him know. And the only reason that the location was moved was because off of me being on probation, my mom had put me on a lease. And when I got put on the lease, they checked back the lease of the apartment.
Oh, she said a leash.
Yeah.
That would have kept you. We would have known where you were at all times.
Yeah, they put a background on it. And they evicted us from the apartment, but I let my
still. I mean, we're talking about a period of time, sir, that's over a year that you were out. You were AWOL.
So here's what: if judge continues on probation today, like what happened in Harris County, right? Where would you live when you walk up?
1221 Record Street.
And 1221 Record Street. Where's that located?
That's over there off of 45 and
so that'd be Houston.
Yes.
So if you walk out the door, you have to. And then if you walk out the door today, would you have a job and where would you work?
Downtown at Honey Drizzle at a restaurant. I'll be washing.
You be washing dishes.
Washing dishes.
And Honey Drizzle, that's like a little restaurant.
It's a home place.
So you set up for a job right now. You got a place to stay right now. Yeah. And then the other thing was contacting you by telephone. Will you have a telephone if you get out today?
Yes, Your Honor. My mom was just at T-Mobile, just starting, me and my brother some lines.
And then they said that they had a hard time contacting you. Do you know your mama's telephone number right now? Do you know it?
Yes, sir.
Can you give it to the probation officer right now?
Remember, I called her.
So you do have, so you'll be living with your mama. They have your mama's telephone number, and you also be working with Honey Bizzle, right?
Yes, sir.
So you prepared right now to be a productive citizen if you walk out the courtroom.
Yes, sir. And go to school for my GED and follow and get in the trade.
Where would you go to school?
At Houston County Academy.
And has the paperwork been processed to get you
through Houston?
So we start in school. Well, school has already started.
Yeah, they told me that I was supposed to start school in 12.
Hey, go ahead. So based upon all of those things, that's why you asked them that you be continuing on supervision. Anything else you want to say, and that's it.
All I can say is, always asking my people to do good.
Where you, who are you getting your drugs from? On this marijuana? Who was that? You're looking around. Who is it? You're not going to tell, are you?
I would, but it just be around.
Where? Who'd you get it from?
Who'd
you get it from? That you tested positive for? No, probably. Who'd you get it from?
One person. Yes, sir.
Yeah, I'm just curious. But to this day, you're not going to give that information out.
I don't know the person.
Yeah, you do. You know where you did it. You just don't go drugs or us and check in, and you know where you're getting it from. In fact, I think we know. All right, anything else? If not, I'm going to find as follows that the defendant has pleaded true voluntarily, knowingly, intelligently to allegations 1, 2, and 5 of this motion to revoke unadjudicated probation. And that is enough to grant this motion by ponderance of the evidence or greater. It is granted. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There was sufficient evidence supporting his guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of assault on a public servant. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. And you will be given credit for all time you have served in accordance with this. Do you understand what has happened today, sir? Yes. Okay, that is all. Desmond Parker?
Yes, he's with us.
What are we doing on Mr. Parker?
I sent that to you, the paperwork on him. That's a plea.
On Mr. Parker?
I need to,
I don't have it yet.
I'm working on it, Judge. I need to fingerprint them.
Okay, I got it here. Go see this lady real quickly. She's going to thank you. Thank you.
Please raise your right hand. You swear or confess that the truth of the servant and the truth shall be God. Each of your right thumb time. Okay, place it flat right there. Each up one more time. Place it flat right here. Kind of judge.
24 CR 209 plea is called the State of Texas versus Desmond Parker. That's you, sir?
Yes, sir.
Present with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? When we proceed in summary.
Yes, sir.
In summary, this indictment alleges that on or about September 26, 2024 in Jefferson County, Texas, you committed a first degree felony of aggravated robbery. Do you understand what you were charged with here, sir?
Yes, sir.
If convicted of a first degree felony such as this, you face a term of life in prison or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case. You will be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years in length, fined $500. There will be terms and conditions of probation, which are normal and customary for the time. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment? Guilty or not guilty?
Speak on guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence?
No, it doesn't.
Without objection, it's admitted. Among other things, the states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are given up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All true, so help you God. State, that's for you to say. Yeah. State's Exhibit 1 is tendered into evidence and without objection.
No objection.
Admitted. I'm going to follow this agreement. And again, you're pleading guilty here voluntarily, knowingly, intelligently, and based upon discussions with your attorney. So, State's Exhibit 1 has been tendered. You've reviewed it. You signed this document. Did you see it?
Yes, sir.
And are all the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence and without objection admitted. Okay, this states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. An indictment's been read to you. You were guilty of the crime charged and any lesser included offenses, and you are giving up your rights to a jury trial, the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. I'm going to make the findings that you have entered your plea voluntarily, knowingly, intelligently. There is sufficient evidence supporting your guilty plea here from State's Exhibit 1 to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer any finding of guilt, postpone that. So long as you follow these terms and conditions of probation, you will be placed on deferred or unadjudicated probation for 10 years. The probation officer is going to go over this. Please make sure you follow these. If you fail, your probation could be revoked. You could then be found guilty. You can be sentenced to life imprisonment. Because there was a deadly weapon, namely a firearm used. If you go to prison, you would not be subject for parole until you served at least 1/2 of the sentence. Do you see how much is riding on you doing well on probation? Are you going to do well?
Yes, sir.
Good. All right. Well, just don't talk about it. Do it. Okay. See the probation officer. Fix this. Brian Smith.
That's right.
Smith. Brian Smith.
I need him to come here for something, please.
Brian Smith.
Brian Jeffries. Will we been on this from the 5? Oh, that was, yeah, I think she did.
You need to see him.
Yeah.
Go see that lady right there, Brian. See that lady? She's gonna swear you in, take a thumbprint, and then we'll take.
First 5 minutes, you swear all times, tell the whole truth. and the whole truth. Right there.
We're only going on paragraph 1.
Right there.
We're on,
Go stand in front of him.
we're only going on paragraph 1, right?
Yes.
Okay. The 24 CR 840 is called Brian Jeffrey Smith. That's you, sir?
Yes, sir.
Present. With your attorney, Mr. Adams, and state's attorney does. The defendant, we have a formal reading of the indictment and arraignment here. Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about December 2nd, 2023 in Jefferson County, Texas, you committed a 3rd-degree felony of fraudulent use or possession of identifying information. And these are items no less than 5 up to 10 items. So it's a 3rd-degree felony, right?
Correct.
You're facing a 3rd-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
The agreement's been reached. You would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Is that you understanding?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, so guilty or not guilty? Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Yes, sir.
Show you this on to State's Exhibit 1 here. Did you sign this document, understand it, discuss it with your attorney, or the contents true and correct?
Yes.
State's Exhibit 1 tendered into evidence without objection?
No objection. No objection.
It's a no. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are given of your rights to a jury trial and the rights to appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
Are you pleading guilty now voluntarily, knowingly, intelligently to this offense? All right. State's Exhibit 1 is made a part of the record for all purposes. Is there any restitution owed in this?
I didn't see nothing.
You're not? Okay. Nobody lost money on this. I'm going to find, if nothing further, and follow this agreement that you are pleading guilty voluntarily, knowingly, intelligently. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this 3rd-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years in prison. That will be suspended. You are placed on regular probation for 10 years. Those conditions of probation will be reviewed with you here by the probation officer and signed. You will begin probation and do well. Thank you. Thank you. Thanks.
And I think that's it, Judge.
Thank you.
What's that, Judge? The second is my first problem.
I'll let you pass on that.
Thanks, Judge.
Okay. Well, thank you so much.
The only other one I got is Jesse Maddox, but he said he's not taking no plea. No. But other than that, that's it. Everybody else played.
I don't see it on here again.
It was reset.
Oh, that was reset. Oh, okay.
Wasn't able to be brought on.
Okay.
Well, we good then.
Okay.
Thanks, everybody. Thank you.
Yes, sir. Thank you. Kevin Hall. That's Mr. Burbank, who's not here. Keontae Willis.
Okay. Judge, we have recently requested discovery. We had a prosecutor who is no longer with the DA's office. We do not have an offer. So we are going to request more time.
How much?
At least 4 weeks.
What if I gave you 4 weeks?
That sounds fantastic.
Okay. Good.
Judge, in the interim, my client has filed a pro se motion to reduce his bond. And he'd like to be heard on that. I can file a motion if you'd like for it.
Yeah, we don't, that's hybrid and we can't do it, file it and then we'll get it. Yes, ma'am. I'm looking at, looks like 25 CR 715, deadly conduct discharge, a firearm, a 3rd-degree felony with a prior robbery conviction out of Lafayette Parish. So that's a 3rd, turns to a 2nd. The other 25 CR 717, unlawful possession of a firearm by a felon. It's like that. So I guess the same event.
Yes, sir. It came out of the same
I
circle.
don't see a prior conviction on that because they're using the felony prior conviction to make it a 3rd-degree felony.
Yes.
That's, I've seen these work out. The way this is done, it works out. But anyway,
We hadn't had.
how much time?
I mean, at least 4 weeks. to review
Okay,
this.
4 weeks. Okay, thank
Do you
you.
want to do the bond here? Yes, do you mind? Yeah, we can do it. When you can file it. We'll do it all at the same time. That works for me. Okay.
Tandra Campbell, thank you.
And I believe that's all I have for you today. Your release.
Yes, ma'am.
You need to be brought out. Campbell.
Campbell.
You're gonna need a time ready.
I don't believe I've ever heard of a first name like a Tandra.
We got a lot of strangers.
Amelia, family here.
Yeah, we did.
Let's see, this lady, she will take your fingerprint and swear you in, sir. Thank you.
Then. Yeah. More change files and where.
I'll take care of
Our 558 is called Tandra Campbell. That's you?
Sir.
Present with Mr. Dusler, your attorney in the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in sum?
Yes, sir.
In summary, sir, this indictment alleges that on or about April 29th, 2025 in Jefferson County, Texas, you committed the 2nd-degree felony of aggravated assault with a deadly weapon. Do you understand what you were charged with here?
Yes.
If convicted of a 2nd-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached where whatever sentence shall not exceed a cap of 10 years in prison. So it looks like we are looking at no less than 2 nor more than 10 years confinement in prison. Also, an option could be deferred or unadjudicated probation up to 10 years in length of the probation. Regular probation would not be an option because there's a deadly weapon alleged to have been used. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Voluntarily, yes.
And because you're guilty?
Yes.
Yeah, okay. Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents true to us? State's Exhibit 1 tendered into evidence?
No objection.
Without objection admitted. This states, among other things, you were mentally competent to enter your guilty plea. It's freely and voluntarily making oath. You've been charged with the indictments from Judge. You've read it. You were guilty of the crime charged with any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. We're going to need a pre-sentence report. We're going to, the probation office is going to come talk to you, get your version. We got to do a pre-sentence report. Everybody will come back and place whatever additional evidence you want me to consider, make arguments, and then I'll make a decision.
Okay.
We'll do that. How long?
It'll be about 5 weeks, Judge.
Is 4 good?
I'll have to get with the probation.
Okay. So we're going to reset 4 weeks, okay? Thank you, sir.
Thanks.
Wesley Davis.
We didn't have brought out just. Wesley Davis.
Please, show it off.
Wesley Davis.
And please come out. You need to see him first. Yeah, she needs your fingerprint and she'll swear you in for the plea. Thank you.
David, you swear, right? Yes, you start with how the records of you can
I swear.
Okay, you got your right thumbprint. Okay, and place it flat right there. Shake it up one more time. Right, place it right here. Okay, let's judge.
Right here. 25 CR 711 is called the State of Texas versus Wesley Davis. That's you with Mr. Dusler, your attorney in the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about May 7th, 2025 in Jefferson County, Texas, you committed the 3rd-degree felony of deadly conduct with a firearm. Do you understand what you're charged with?
Yes, sir.
If convicted of a 3rd-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
So that's how to.
Agreement's been reached. You would be pleading guilty. Whatever sentence shall not exceed a cap of 7 years in prison. So we are looking at no less than 2 nor more than 7 years confined in prison, or deferred or unadjudicated probation can be assessed up to 10 years in length, and you'd be placed on probation. Regular probation is not an option here because a firearm was used in the commission of this offense. So is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily because you are guilty?
Yes, sir.
That'll be his words. Yours.
Kid.
He can help you, but you are guilty.
Yes.
All right. Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents all true and correct? State's Exhibit 1 tendered into evidence without objection admitted. This states, among other things, you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states so happy you got it. States Exhibit 1, made a part of the record for all purposes. We're going to have to reset this, set it for the hearing with the probation office's report so that we can refer to it during the hearing, and then all parties get to submit any additional evidence you want me to hear, and then I'll make my decision. So when can we do that?
We'll see if we can put between 4 and 5 weeks. So
Okay.
I'll stay in contact with the probation
Okay.
office.
All right. We'll see you back, sir. Thank you.
He's so pretty. You go for more regulation.
Jared Dobbs.
Mr. Fingerprint.
Yep.
First, right hand, you swear or affirm to the truth, the whole truth, and nothing but the truth, self you got. Either girl's right thumbprint. Place it flat right here. Ink it up one more time. Place it right there. Okay, go in front of the judge.
This is Davis. Hi. And we now call 25 CR 68, the state of Texas versus Jared Brian Dobbs. That's you? Sir. Present with your attorney. Mr. Dusler and the state's attorney. Does the defendant waive a formal reading of the indictment and if your attorney proceed in sum? Yes, sir. In summary, this indictment alleges that on or about November 24th, 2024, in Jefferson County, Texas, you committed the state jail felony of evading arrest detention with a previous conviction on May 30th, 2009, out of county criminal court at Law 6 in Harris County, Texas, where you were convicted of evading arrest. So
That's all we're going to proceed.
paragraphs 1 and 2, I think it's a second paragraph.
Yes.
Anyway, those first two parts constitute a state jail felony. You are facing no less than 180 days up to 2 years in the state jail and a fine not to exceed $10,000. Do you understand? Agreement's been reached where you would be pleading guilty. What is this, a lesser included? Okay, you would be found guilty of the state jail felony, though punished though under section 12.44 of the Texas Penal Code, which states that you can be, under certain circumstances, your state jail felony punishment can be reduced to misdemeanor punishment. It's still a state jail, but it's punished as though it were Class A misdemeanor, and which is up to 1 year in the county jail and a fine up to 1 year in the county jail. Here, there was an agreement that you would be sentenced to 120 days in the county jail under section 12.44 of the Texas Penal Code to satisfy this state jail felony. Then you would be convicted of the state jail felony, but punished as though it were a Class A misdemeanor punishment of confinement. Is that your plan? Yes. If I follow this agreement, you have no right of appeal. Do you understand? Yes, sir. How do you plead to this, sir? Guilty or not guilty to the state jail felony? Guilty, sir. Are you pleading guilty voluntarily and because you are guilty? And this prior conviction out of County Criminal Court of Law 6 of Harris County, Texas in 2009 of evading arrest. Is that true and correct as it is alleged in this indictment? And are you pleading true and correct to this voluntarily and because it is true? I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents true and correct? Sir. State's Exhibit 1 tendered in evidence without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied by the representation provided by your lawyer. All true, so help you God. Yes, sir. State's Exhibit 1, part of the record for all purposes. Please send us reports. Yes, sir. I will follow this agreement and find you are indeed pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of evading arrest or detention with a previous conviction in paragraphs 1 and 2 and in this indictment. I am sentencing you, though, under section 12.44 of the Texas Penal Code, which provides Class A misdemeanor confinement under certain circumstances. This fits it for a state jail felony. I am following the agreement. You are hereby sentenced to this state jail felony to confine in the county jail for 120 days. You will be given credit for all time you have served toward that. Do you understand what has happened today, sir? Anything else? Yes, that is all. Thank you. Good luck. Yes, this thing, just to get out of it, it takes 5 or 6 steps on the computer. You know. Michael Mincy.
That's a motion to revoke that the state is dismissed.
That's very good. That motion has been dismissed. Do I need to sign anything?
Yes, sir.
I did.
I sent in a dismissal.
You did.
Oh, sorry, that's in my queue. Let me send it off.
Okay. Do we need him now?
No, sir.
You sure? Well, let's bring him out. Give him the good news.
I gave him the good news, but if you want to write it for
play Santa on the bench. Michael Mincy? Mr. Mincy? All right, we have, you were here with Mr. Dusler, your attorney. We have before the court something filed May 28th, 2025. A motion to revoke your probation stand-by. Where this states you were placed on this. You were sentenced to 5 years in prison. That was suspended. You were placed on regular probation for the 3rd-degree felony of misapplication of trust funds. And this motion to revoke your probation is requesting that your probation be revoked and you can be sentenced up to 5 years in prison. However, I've just dismissed this. And you're going to continue your probation. Do well on this, okay? I don't know what the deal was behind this, but I'm glad this has been fixed. And
Mr. Mincy needs to thank his probation officer for speaking up for him. Otherwise, if I'd have put him in prison.
You're here to fix mistakes and fix. You need to not keep fixing mistakes, quit making mistakes. Okay. Yeah. You can do it. The finish line is right there. Don't stumble at the gate or stumble at the finish line. Complete it successfully. Okay. All right. Go and sin no more. Okay. No more violations. Okay. Thank you. Did you have something else?
Yes, actually.
You do? I don't see anything.
One more.
Oh, Ashland Wilson.
Ashley.
It's right here, Judge.
The Senate said we have a PSR.
Who's going to be representing the state on this? Ashland Wilson, please. Ashland Wilson. Come on.
Look, it's a baby.
It's you again. Let's go.
You want to do it?
Your makeup is beginning to wear off. You've been showing up so many times here today. This. All right, 24 CR 1327. You are Ashton Marvin Wilson.
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. Earlier, you pleaded guilty to this first-degree felony of aggravated robbery. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it?
We have reviewed it. There are no corrections.
Not from the state, just.
It's made a part of the record for all purposes. The agreement is whatever sentence shall not exceed a cap of 10 years in prison. So we would be looking at no less than 5, nor more than 10 years confinement in prison, or deferred or unadjudicated probation would be an option. Because a firearm was used in the commission of this offense, regular probation is not an option. Do you understand all of this?
Yes, sir.
Okay. Go ahead, Mr. Dusler, you may go on behalf of this defense.
Your Honor, he's asking the court for deferred adjudication probation. This young man is 19 years of age. He has no felony criminal history, very little history of any kind. As the PSI correctly points out, he did not grow up with a very good social structure. His father has been incarcerated. His mother's had criminal trouble as well. But he's trying to keep his life in order. This was a very stupid thing that he did. We've talked about it. There was a dispute among a bunch of people that they had been gambling together. They had some problems. He wanted his money back, and pulling a gun on somebody and brandishing a firearm, it's not the thing to do. I think he recognizes that. He's been sitting in jail a good while now. The one positive thing on his behalf that I've talked with him about is he is still trying to complete school. He's in the 12th grade in high school, and he's further along than a whole lot of other people in his situation at this age. He wants to complete his high school education and live a productive life. And he realizes that this was one really, really stupid thing, and he feels like the court will give him an opportunity. He could successfully complete probation, and by the opportunity of deferred adjudication, if he does successfully complete it, it keeps this young man from having a felony conviction, which I think would really benefit him in the future. Have I pretty much said everything correctly?
Yes, sir.
Is there anything else that you want to add for the judge?
Yes, sir. You said it pretty much.
Okay. We're asking for deferred, Your Honor.
Stay.
Judge, this is how our society's become. Evidently, you have a dispute over something, you pull guns. And this was 4 individuals robbing 1 individual. And they were just out having a good time hanging out. And next thing you know, they're accusing somebody of cheating and start pulling out guns. They rob this individual. You can see that he's scared. He's afraid of retaliation when this young man gets out. He thinks that this person should go to prison. So we would ask for the 10 years, Judge, the cap.
Mr. Wilson, what would you like to say? Did you hear what he just said?
Yes, sir.
He's asking for 10 years in prison. which is far less than the maximum you could get. You're looking at life in prison, which would mean you wouldn't even be reviewed for parole until you did 30 years.
Yes, sir. I would honestly say I did honestly commit a crime out of let's say madness. Somebody did cheat on the game.
So you quite naturally threatened them to kill them with a firearm.
No, sir, I didn't threaten them. I just demanded the money back.
No, that's not what this says. The pre-sentence report's been admitted. And it says here that, let's see. That following the investigation, Detective Gillen concluded that Ashton Wilson, you intentionally brandished a firearm and pointed it at the victim during the robbery, which prompted him, the officer, to seek a warrant for your arrest. That's what this says, buddy.
Yes, sir. On PSI thing, when the question asked me what happened, I said that I pulled the gun and demanded the money back, but not with intent to kill or harm him. I was upset about the game, about the gambling.
Let me ask you this.
Sure.
If I pulled a gun right now and stuck it to your forehead, what do you think's about to happen? What do you think's about to happen? I'm putting you in the position the victim was in.
Yes, sir.
You had all the authority and power, which you're not supposed to have over somebody. That's not for you.
Yes, sir.
The supreme being is supposed to have that power, not you. And if I put a gun, what do you think? The next moment, you can very well die. What do you think he thought? Same thing. You're going to later say, well, I didn't intend to kill you. How does that take back the fear and what was going through their mind, thinking, I'm about to end my life on this as a living person is about to end, and I don't have control. Somebody else has control over my life, which isn't supposed to happen. That's not the way we're supposed to live, is it?
No, sir.
That's the way you did it. You assumed the power and authority. You can say, I didn't intend, but you think anybody believes that when they've got a gun to their head?
No,
yeah, that's going to make them feel better later. I mean, they'll wake up with nightmares their whole life. So what they tell me, well, that would be reasonable. It doesn't matter what you intended, it's what you did. That speaks for itself. I bet you didn't say, I'm putting this gun to your head, but I'm not going to really pull it. I don't intend to do anything to you. I'm just doing this. You didn't do that. You made them think they were about to die. Can you understand how that's terrible?
Yes, sir.
You had all the power, and that's not the way it's supposed to be. That's not fair. Well, he's asking for 10 years in prison, which isn't unfair. I bet you the victim kind of feels like, what am I supposed to do? I got to live with this my whole life. And he just gets 10 years. And then he's released. I'm the one that suffers my whole life. Okay. That seems awfully unfair. You're not supposed to put people in a position. But when you take out a gun and you point it at them and threaten them and say, what was taken from them here? What was taken from him? Searched his pockets, stealing about $800 in cash, a cash app card, and other personal items.
Judge Stephen, I wanted to say that that actually no one took any money from him. But they did take someone did take some marijuana from him. I don't know what he actually told the detectives. I'm not aware of, I never seen the paper of an indictment, so I don't know actually what he told the detectives. As I can remember.
How do you know? How do you know what was in his pockets?
I don't.
Well, then well, why are you saying there isn't any if you don't know? He said the police that there were $800 in cash they took. How do you know that he's not telling the truth?
Because after the robbery, no one had $800, sir.
Well, well, you were sitting there watching. Did you see them pull his stuff out of his pants?
Did you? I was watching him. No one went into his pants.
Sir?
I said, yes, sir. I was watching him. No one went into his pockets.
Well, where'd they get the marijuana from?
He had a bag of marijuana.
Where?
He got it from the trunk, sir. From the trunk of the car.
How did y'all get it?
He handed it over, sir.
Huh?
He handed it over.
At gunpoint?
That was actually before gunpoint. He was actually selling.
Wait. So what did you take from him at gunpoint?
That's what I'm saying. They actually didn't take nothing from him because they had an officer doing a patrol.
No, you had the gun to them.
Yes, sir.
Well, what did you get from him?
That's what I said. I told the probation officer.
You just pulled a gun to somebody who didn't have anything to give?
Sir, what I told the probation officer when she came to see me, that when I pulled the gun, to demand the money back. I had a police officer doing a patrol.
Wait. What money back?
The money from the gambling. The money that I cheated out of. I demanded it back. Someone screamed and said the police right there. We turned around, we sent a police crew. Everybody left. Everybody took off running. No one never handed the money over.
You put a gun to, what did you put it to his head? What?
No, sir, just in front of us. Like,
what do you mean?
At chest height.
You mean to his chest?
Yes, sir.
Oh, okay. Well, that kills somebody, right?
Yes, sir.
Okay. And you were there to steal his money. To steal the money. To take it from him at gunpoint, right?
Yes, sir.
You don't see anything wrong with that?
I do, sir.
Okay. Anything else? No. Your criminal history, as it looks like you had an unlawfully carrying a weapon charge in Harris County, that was dismissed.
Sure.
And then it looks like you have an evading arrest or detention of Class A misdemeanor pending over there, right?
Yes, sir.
Okay. Felonies, this is the only felony, correct?
Yes, sir.
Right. Yeah, you can talk all day long about what your intent was, but when somebody has a gun to their chest and there's nothing they can do, they're defenseless. You have all the power. They'll think of that their whole life. That'll be in the back of their mind forever. It's what haunts people forever. It's a nightmare that they have to live with. You understand? That's what you did. I mean, that's the funny. I mean, that victimizes them forever. They just don't forget it. All right. I'm going to find that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of aggravated robbery. I am going to follow this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 8 years. You will be given credit for all time served. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. You are facing life imprisonment on this. You know that. You must do better. You must not harm people like this. Anything else? That is sad. On Jenna Horn, no, hold on. On Jenna Horn. Jenna Horn, is she in custody?
Yeah, there's papers in that they would call in.
Stand by. I don't have, you have a file.
Alrighty, Judge.
Let me look at that for a second.
What?
The file.
We looking for him.
Where is it? When you say pulled it, what do you know? Oh, you took it, you kept it. I want to let me see the pre-sentence report because I want to see what it's set for sentencing, probation. I don't want her to sit in jail.
Sam, but she's not here, Judge. We would have to bring her back.
I know, but she's,
No, I understand, Judge.
yeah, it's not her fault she didn't come. It was the lawyer's not. Sorry. While we're waiting, what did you have to say, Ms.
I have Terrell Thomas on the trial docket today. There's been a bunch of confusion back and forth because I had a specially set matter. However, that has changed and so I've become available. I believe Mr. Burbank's case is up number 1, but I just wanted to make the court aware that if something happened with that one, I don't know where the court numbered Terrell Thomas.
But you weren't here. I didn't have any information one way or the other to do much. Yeah. So he's looking at, he's facing.
It's triple A.
Get probation. No, I'm talking about this other case. That's sorry. That's a problem. Mr. Groveland absent. Give me his files, please. This file on basically the trial document. This file. What was the defendant's name?
What's your client's name?
Terrell Thomas.
Well, just be around that when we have the trial docket.
Thank you.
Time. Yes, thank you.
Thank you.
Yeah, on Jenna Horn's case, yeah, that's a cap of 5 years on this one. So the defendant is eligible for probation and is looks like not eligible. Who's on this? On Jenna Horn? Yeah. It says there was a pre-sentence report here in 2015. Jennifer Horn was placed on deferred or unadjudicated probation, and that states it was revoked in 2017, 800 days jail. What do you think that means? You think that was?
It's a strange sentence.
Yeah. Is that a conviction or not?
Yes.
Okay, so
It says
the
revoked
defendant
800
was-
days jail with, what is? I don't know what that is.
Okay. So the defendant's eligible for probation for Meade, but not in front of a jury.
Correct.
Okay. Yes. Can I need to, I guess, reset this one. Can you put it tomorrow's docket? Yeah, get David's stuff. Yeah, we can get it reset. Let me see this first time. And then Ashley Nielsen, looks like that was reset.
Yes.
And then make Rick Kirkwood reset, David Wiggins reset. And then we go to Gary Boudreau. Hold on, who's coming? What are we doing?
Your Honor, I've never obtained the online discovery. I'm just waiting on the digital media.
There's on Gary Boudreau's case. What's 2 years old?
He just got arrested on it 39 days ago.
Really?
That's why.
Yeah.
Yeah.
Okay.
He was benchmarked.
How much time do you need? Yeah. You get a fair amount.
Just maybe 4 weeks to get everything.
It's we said five. It's 5 minutes. No. Alan Pennell.
Yes, Your Honor. He's in custody, just so we know now. Yeah.
Still.
Alan Pennell.
You're bringing him out. Yeah, see some like the MTR can.
You're Mr. Pennell?
Yes, sure.
Okay. Now, Arlen Pennell, 2137759. What we have is a motion to revoke unadjudicated probation that's pending, correct?
Yes, Your Honor.
Okay, what are we doing today?
Judge, we have a agreement for a cap of 15 months to SEC with the new offense. My client is going to plead true to conditions in the MTRP and plead guilty to the new offense. So it's up to the court whether or not they would like us to do that now.
Is that the plan?
Yes, sir. Yes, sir.
All right, then you are Arlen Pennell.
Yes, sir.
Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary?
Yes, Your Honor.
In summary, sir, this states that on August 17th, 2022, so we're going on 3 years ago, that you were placed on deferred or unadjudicated probation for 5 years for the state jail felony of theft.
Yes,
Is that true?
Yes, sir.
Allegation one states you committed the offense of felony theft on or about October 26, 2020. 2022 in Jefferson County, Texas. Is that right? So we're talking about 2 months out. 2 months after September, 2 months afterwards. Yes, sir. Yes, Your Honor. Is that true or untrue?
Yeah, I bought a diesel so true.
Has he been an absconder?
Yes.
Okay. Yeah, and that's, took off and then the defendant. So you committed the offense of felony theft on or about October 26, 2022 in Jefferson County, Texas, in violation of this allegation one of the motion to revoke probation. Is that true?
So
You okay? Yeah.
I have herbal allergies, Judge. I'm sorry.
water.
Number two, you failed to report to the Jefferson County Probation Office for the months of September, October, November, and December. This was later filed in this motion was filed February 7th of 2023. But did you abscond and not report since September of 2022 to the probation office here in Jefferson County?
Yes.
So is that allegation true?
Yes. Yes.
Are you pleading true then to allegations 1 and 2 of this motion to revoke probation voluntarily, knowingly, intelligently, and because they are true as they are alleged?
Yes, sir.
Do you understand that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked. You can now be found guilty of this state jail felony, correct, of theft, and you could be sentenced to no less than 180 days up to 2 years in the state jail.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes.
I noticed there's the probation of order that was assessed by me almost 3 years to the day ago, shows restitution in the amount of $5,000. Was that ever paid back to, I guess, the complainant, Elvin Wedgeworth?
Yeah. No, sir.